when we start talking about the Specific Claims Tribunal, I use a little bit of a timeline because for me, I'm going to start using this word called assumed Crown jurisdiction. And it's so important to me, I'm going to say it again. Assumed Crown jurisdiction and sovereignty. Because when you start thinking back through history, and I always go back to this thing called the doctrine of discovery, and how everybody now in this world is starting to look at that doctrine of discovery as an illegal racist doctrine. Start from there. Start from that premise. And then things called the terra nullius, the vacant land, to the Mabo decision. And then things from the Royal Proclamation of 1763, when the Crown and King George started recognizing Indians and that we have title to lands and territories. The 1867 BNA Act, Section 9124, where the federal government is responsible for Indians and Indian lands. It doesn't say Indians on Indian lands, but Indians and Indian lands. A further recognition of our title to territory. Going on from there, Section 9124, I always acknowledge as well this thing called the 1870 Royal Order in Council. That's a very important piece of legislation. And some of you may not be familiar, but what it is basically the Crown gave assurances to Canada at the time that when the Northwest Territories was taken up for settlement from the non-Indigenous peoples, that it says the Aborigines would be compensated on a fair and equitable basis. And I don't know if I'm an Aborigine. Maybe they were saying, I'll add a little bit and go to Indigenous peoples, that it's referring to. And that's an important piece. When lands are taken up for settlement, compensation. And then through the treaty-making process, through the number treaties, Robinson-Huron, peace and friendship treaties, all of those things, the relationship is with the Crown. And whether you're talking about the covenant chain, the relationship is with the Crown, high up nation to nation. And the points we make, we always hold up and acknowledge as Indigenous peoples with the inherent right to self-determination, because we have our own lands, our own laws, our own languages, our own people, and our own identifiable forms of government. Things that qualify for that inherent right, not only amongst our people, but in international law. And so we cling to things like the UN Declaration of the Rights of Indigenous Peoples, the bare minimum in international standards about our rights and title. We lift them up. All the way down to, from the treaties, to all the provinces coming part of Confederation now, in our case Saskatchewan, BC years later. We always have that fight about jurisdiction, federal government jurisdiction, provincial government jurisdiction, and then our jurisdiction. Our jurisdiction as Indigenous nations. And then right into the 1982, Section 35, existing Aboriginal treaty rights. And so when you look at the timeline, and you start talking about the Claims Tribunal, and this is part of a Justice at Last process that was agreed to 5 years ago, and that there was a review to be done. But because the honor of the Crown is so important to our people, that duty to consult and accommodate is so important to our people, the Crown is doing their process. But as Indigenous nations through the AFN, we thought, the Claims, Chiefs Committee on Claims thought, we should do our own. Let's do our own. And so this is the second piece of that work. So again, I lift up the Chiefs Committee on Claims. And the Chiefs and Assembly mandated this work to continue. Because we want to get directions from you, recommendations from you, how to make it better, what's working, what isn't working, whether we need more research dollars, like Bryan was saying, how do you get that first no so you can get to the tribunal, no to your claim, in order to get to, there's so many things to recommend, make recommendations on how to make it better, and that's what we're here to do today. Listen, get the recommendations from you, you work with it, and how do we make this better? And the task force team here, the experts panel, have some time. They've got some work to do till the end of April, April 13th final report into me. And then we've got to figure out next steps on how to make recommendations. And it's not only about the tribunal itself, because Justice Slade was clear. Without additional human and financial resources, that tribunal will fail. That's the tribunal itself. So that's one piece. But there's a whole other ranges as well leading up to getting there that we can make improvements upon. And so that's what we're here to do today. The importance of oral history, the importance of the Bellegarde decision. Our elders' oral history is admissible, and that's how we are as Indigenous nations. Verbal, oral, our teachings are passed on. That's very important. What role does that play? How does that fit in? How do we access that? How do we capture that so it is admissible in a good way? And our ultimate dream someday, after we do this work, when we call it justice at last, it really was about creating a better process. Because these claims, whether they're treaty land entitlement claims, specific claims, comprehensive claims, are valid, lawful obligations. And the longer it takes this crown, this government, to deal with them, it'll just go higher and higher. So dealing with these claims is in the best interests of not only our people, but for all Canadians. All Canadians have a vested interest in this, dealing with these things in an effective way. Peaceful coexistence and mutual respect between our peoples. And my last comment would be this, my friends and relatives, is that very important work. One day, the dream and vision of our people and our nations are that we break down the myth that Canada was founded on just two founding nations, English and French, and that there's only two systems of law in Canada, common law and civil law, that one day we'll see our First Nations governments recognized by other governments as well as legitimate governments with a huge role that we've played, that we're not a third order government but a first order government, and that our laws will also be recognized. Because we have First Nations law, we have Creator's law. And that's ultimately where we want to go. That's down the road. We say Tsuut'ina, down the road in the future. So my friends, my relatives, it's a very important day, the last day. I lift you all up, Chief Chapman, again for your work, Chief Jonathan for being here, because you're going to take up the torch here to help in going this forward, and to our commissioners. So with that, I'll say that much, and I look forward to hearing the rest of your comments for the day. Thank you so much for listening.
This expert panel has been struck by the AFN's Chiefs Committee on Claims in consultation with the National Chief Bellegarde. While we are appointed through the AFN, the work that we do is being carried out independently, consistently with our terms of reference, which are available at the registration desk outside this room. Our mandate is to function independently, to receive and assess information from First Nations and their representatives, and from others as determined by us, and to use this information to make our own independent recommendations on improving the specific claims process, policy, and legislation.
The Justice at Last policy in the Act was supposed to be about establishing an independent, timely process to achieve reconciliation through fair compensation to First Nations for Crown breaches of lawful obligation or outstanding obligations. What is at stake here is not only the principles of honoring treaties and reconciliation, but hundreds of millions, if not billions of dollars in outstanding compensation owed to First Nations. It's been estimated to be in the range of $5 billion. And I can tell you the claims in our office, if properly settled based on expert valuation reports alone, are over $1 billion. For 15 years prior to the introduction of the Claims Commission, I appeared 4 times before Senate and parliamentary committees and wrote numerous papers seeking an independent, fair, expeditious, and impartial tribunal. Well, the old Chinese maxim of being careful what you ask for really applies. Because as a whole, the Specific Claims Tribunal has been an unqualified and unmitigated and very expensive disaster for First Nation claims. And not only that, it appears to be getting worse with administrative changes, fiscal constraints, and damage to the integrity and reputation of both the process and the tribunal. It has become worse than the simple option of amending the Federal Court Act to allow claims to appear before it without the defenses of latches or limitations, and in fact, it is arguably worse than the claims process that preceded it. Now, others will give you numerous examples of how the situation has deteriorated, but just giving you some directly from my own experience, we settled an average of a claim and a half a year for 20 years. In the last 10 years, we've not been able to settle one. We have over 30 in process, and none of them have prospects for fair or imminent settlement. Canada has strangled the specific claims process, withdrawing all kinds of resources, people, personnel, funding for First Nations, etc. The number and value of claims settlements has dropped dramatically, while the time and costs of settlement have risen exponentially. But most importantly, claims has gone off the political and policy radar in Canada. In summary, the Specific Claims Tribunal Act, as secretly negotiated and agreed upon by the AFN, gave the Harper government the perfect process and excuse to avoid, deny, delay, and minimize claims, and in particular, the expensive, outstanding treaty entitlement obligations. It played directly into their hands a primary goal of reducing costs for Aboriginal expenditures, while at the same time giving them an excellent mechanism to delay treaty settlements and claim settlements. Now, I want to specifically focus on how the tribunal adversely affects claims negotiations. In Justice at Last, Minister Prentice, as he then was, we say, said the following: the Government of Canada has a policy in place to resolve claims through negotiations rather than the courts. To honor obligations and right these past wrongs, Canada negotiates settlements that provide justice to First Nation and fairness and certainty to all Canadians. Negotiation is always better than confrontation in securing peaceful settlements that respect the interests of all parties. That was the intent. In fact, what has happened is, to understand the impact of the tribunal on negotiation, you have to understand the concept of a baton in negotiation, which is the best alternative to a negotiated settlement. It's a common term in negotiations. And it simply says that the stronger mechanism or alternative you have for achieving your interests away from the table, the more powerful and effective you can be at the negotiating table. Well, the tribunal has turned out to be an outstanding baton for Canada and a terrible one for First Nations. And as a consequence, First Nations have been severely empowered at the negotiating table, and Canada has taken full advantage of this by either delaying offers, making take-it-or-leave-it offers, lowball offers, and frankly, conducting themselves at negotiating tables in a way that almost invites, if not forces, First Nations to the tribunal. And what do they then face? They face a government that is committed to spending whatever it takes to abuse that process to delay those settlements. Chief Bellegarde was quoted as saying the First Nation, or Canada, in fiscal year 13-14 spent over $106 million litigating against First Nations. And that amount is only going to increase before the tribunal based on the tactics we see the Crown using before the tribunal. In short, the Crown is prepared to spend whatever it takes in the litigation process to drag it out to avoid settlements. They do that with any groups whose interests they don't find appealing, whether it's immigration, immigrants, public servants, or whoever. And we're now on that list, and we've given them a perfect forum. So rather than being a mechanism to, as originally intended, to avoid long, lengthy, costly litigation, the tribunal has become precisely that. And I've given you an outline of a letter of 3 of our clients to the Minister of Indian Affairs describing this abusive process. On a treaty entitlement outstanding treaty entitlement agricultural benefits. Our clients were in negotiations for 20 years. In 7 years prior to 2010, they spent over $750,000 on joint studies conducted jointly with federal and provincial officials, federal officials, agreeing on terms of reference, process, and principles, agreeing on the consultants. 4 studies were undertaken. The minister undertook a special study himself that came up with a consensus number. The minister agreed to it. 5 years later, we're still awaiting an offer based on that number. And now 2 of the 4 and many more will be going to the tribunal. And what happens when they go to the tribunal? In one case, they denied the eligibility of the claimant in the first place. They alleged by filing 3,000 documents that this treaty entitlement had been provided, though not one of those documents gives a hint of that. They then filed hundreds of more documents arguing that every little program and dollar that they had ever given to the First Nation was a set-off for a treaty entitlement. And in another case, they argued that the Crown's expenditure of the band's capital and revenue trust monies constituted meeting a treaty obligation. This is the kind of hardball, abusive litigation tactics that we're facing before the tribunal. So what is the message here to First Nations? Either take it or leave these lowball options, walk away, or expect years of expensive, abusive, frivolous litigation from the Crown before the tribunal. And that's just not our experience. We've talked to the others in this situation. Before a tribunal that is being manipulated, underfunded, understaffed, and overwhelmed. When the tribunal was set up, it was never expected to handle half the volume that it is seeing, and it was intended to be an expeditious process, not a court of first hearing. And now everything, even when claims and negotiation, in our case for 15 years, now go before the tribunal, they have to start at square one. They have to prove their eligibility, they have to prove the legitimacy of the claim, they then have to fight off, and we don't even know how they're going to deal with compensation, because we haven't even heard any compensation arguments, but we know kind of roughly what the approach they're going to take. And then we have to hear arguments about extraneous set-offs. And then we can expect on these claims for them to be appealed. Because the treaty agricultural benefits claims are the largest single category of outstanding claims in Canada. When I spoke to you, Bryan, in 2007 about this, and you made a reference to it in the tribunal, there were 5. Now in Treaty 8 there are 18. There are another 8 pending. We think the honest value of these is well over $1 billion, and we know in Treaty 6 there are at least 12 to 15 pending, and the value of those will far exceed that. And yet they bundled historic and important treaty entitlements into this claims litigation process and put them on the same value as a misplaced road or a wrongfully surrendered few acres of land. Treaty obligations and entitlements have to be taken out of the claims process. There needs to be an honor-based reconciliation process that deals with treaties as was originally intended by the spirit and intent of the treaties in order to achieve reconciliation, and that cannot be achieved through what is bound to be years and years and millions of dollars of litigation before the tribunal. So that's the good news. If you really want to know how bad it is, you're going to hear from lots of others. We need, and you will not, in my view, not get any headway with this government. We need to plan to have recommendations to go to a new government, and the first one is we need a completely different approach to outstanding treaty entitlements outside of the claims process. They cannot be settled fairly, expeditiously, reasonably within that process, because it has been taken over entirely by the litigators. Entirely. Their validation strategy and their negotiation strategy is all driven by their tribunal litigation strategy. Why would they validate? Why would they negotiate? When they are just gearing up for a major fight before the tribunal on every case. So my advice is, if you once you get your claim in the process, ask for an immediate rejection, go right to the communal. If you get a partial validation, skip it, go right to the tribunal. Because in my experience, in the last 10 years, the negotiating table reeks of bad faith. I could sit here and document to you lie after lie we've been told, evasive comments, misleading statements. In my experience, in 26 claims I negotiated, I have never seen such an abuse by the Crown, such a lack of integrity. And why? Because they've got a bigger and better alternative in their point of view than we have. Our clients, only a few of them have the resources to go through the struggle and cost of the tribunal.
But if you didn't have access to independent third-party adjudication, I don't see how the situation would be improved. You said, well, we could just go to courts and they could waive limitation periods, but that still involves having open access to independent third-party adjudication. The Specific Claims Tribunal is access to independent third-party adjudication. In some whole new system, wouldn't there always necessarily be a rule for independent binding final resolution?
But you know that's what we wanted. That's not what we got. What I thought would happen is when claims were in negotiation, there would be an acknowledgement of the scope of validity, and validity wouldn't have to be proven before the tribunal, and the only issue to go before the tribunal would be compensation. Instead, what we got was, if you don't succeed at the negotiating table, and may have no intention of succeeding on large claims, then you go to the tribunal, and what do you get? You have to start over again from square one after being in negotiations, in one case for 15 or 20 years. Who missed that? Now, I say the federal court would have been easier because at least the federal court can't be manipulated administratively and fiscally like this court is. If we could have these claims go before the federal court with a provision in the federal court rules for not allowing latches and other time-related defenses to arise, at least we're there before a court with some integrity, repute, and clear efficiency. But now we're before a tribunal that is essentially being controlled, manipulated, and funded by the federal government. It no longer has the administrative and fiscal independence that it requires to operate, and its future is in doubt given who we're going to get and the number of judges we're going to get in the future. So I agree, Brian, we need that out of negotiation, binding, authoritative settlement function. But we didn't, that's not what we got, to be blunt. And secondly, sorry, I just lost it. So what we asked for and what we got were not what was intended, and it's actually made the situation worse.
I want to get just your further thinking on the notion that treaty entitlements should be taken out of the claims process. What would that look like? Have you given some thought to what that would look like on the ground?
I would really like to talk with yourselves and other counsel about this. And of course, this really has to be a political initiative led by the signatories to treaty. It's not one that's all that amenable to litigation and lawyer ideas, although we would have some ideas and help on this. This is having Canada come to grips with there is unfinished business around treaties. And it is to be dealt with in the context of the spirit and intent of the treaties, the honor of the Crown, and for some fair and transparent and accountable process for implementing treaties. That's not what we have now. What we have is all those treaty obligations heading into a very long, expensive litigation process, one by one. Canada, hypothetically, could make every First Nation with the same outstanding treaty entitlement litigate that separately before the tribunal. There could be before the tribunal 30 to 50 treaty entitlement to agricultural benefits claims heard. So this process, and the treaties were negotiated collectively on a treaty-by-treaty basis. And we have done a huge amount of work on this provision of agricultural benefits. It's the single largest outstanding category of claim in the country, by far the most expensive. Leaving aside comprehensive claims, I'm talking about with what is now considered within the specific claims process. It needs to be extracted from that process. there needs to be another way to address that. I'd be happy to, I don't, like I said, I want to limit what I can say about this because I think it's fundamentally a political issue, but there needs to be some creative thinking and goodwill in that regard.
I just want to say that I think although there's plenty of room for improvement, lots of problems, the problems in fact are legion, I'm not of the view that we should throw the baby out with the bathwater and get rid of the tribunal. The tribunal is not the problem. It's the department's response, the institutional response to the tribunal in the Act that is, I think, the major mischief that needs to be addressed in terms of any review of the legislation. So I'm just going to start with a kind of a quick background there. Part of my experience stems from our involvement with the tribunal. We've got 10 of the 66 claims or so that are before the tribunal where we represent those First Nations. I won't go into the specific claims action plan, what it was intended to fix. I think a lot of the other commentators have done that, I think, quite well. I'm going to maybe turn, though, to how we measure success. Has this process been successful? And I guess it really just depends on how you look at it. Clearly, the front, and I will make the distinction between the stage 1 and the stage 2, as Mr. Schwartz has put it. The review process by the specific claims branch is irreparably damaged as far as I'm concerned, and I think that that's confirmed by a statistical analysis, and of course the AFN has done a lot of that work already, so I won't belabor it too much, but I think it's helpful to put some of this in context. Of the in 2008, the department said that there were some 300 settled claims. 97 had been rejected on the basis that there was no lawful obligation. 113 of those claims were also closed. At the time, there was a massive backlog, some 500 claims in process. So the overarching objective of the Act was to eliminate the backlog. It seemed like that was the first priority. Now, Canada, in fact, has eliminated the backlog, but I think the way that they've eliminated is the problem. Canada actually, in making representations to a joint committee of the House of Commons and the Senate, had provided information to the effect that Canada accepted about 70% of all claims that had been submitted into the process historically since 1974. So that's actually not a bad rate of acceptance. And the overwhelming majority of those claims were settled. But the problem is that it took some 13 years on average, according to the statistics, to get a decision one way or the other. So that was the problem. So Canada, in response to that, brought in the 3-year limit to review and respond, and Canada has, in effect, responded to all of those 500 claims that were in the backlog. But when you look at the numbers, they're kind of staggering. As of the spring of 2014, a total of 391 claims have been settled. That's actually about 20 per year actually settled through negotiations since the Act came into force. Not exactly the type of progress that you need to see to be able to effectively resolve these. And I'm going to start from the standpoint that there's still about 1,500 or so claims in total potentially in the process. So if at a rate of 20 per year, it's going to take more than all of our probably collective lifetimes to be able to bring this to resolution, unless we do something about it, unless we change it. About 408 of those claims were no lawful obligation. They were rejected for negotiation. So that's up 311 from 2008. So that means, again, I think the stat that I saw was somewhere close to about 88% of the claims were rejected by the department. 328 claims closed. That's up 215 from 2008. Sorry, that would also include in that category closed files, rejected files, and those types of files have been characterized as concluded claims. So the department's number in their audit, I think, was 736 claims that have been rejected or closed as concluded claims, which I think is disingenuous and highly inappropriate in terms of misleading the Canadian public into the false perception that these claims have somehow been resolved. Concluded doesn't mean resolved at all. I'll give you one example of how this process has kind of run its course. British Treaty Annuities claim is a claim from Saskatchewan. First Nation filed a claim with the tribunal. It's been argued. We're awaiting a decision that's pending by the tribunal. That claim was originally filed in 2000. There was research conducted by the department. Took about 8 years to respond. So just prior to the Tribunal Act coming into force, Canada responded by saying, this claim cannot be considered under the policy on the grounds that it falls outside the four corners of the specific claims policy. Canada closed the file, so that's how it's characterized within the process, on the grounds that the right to treaty money, treaty annuities, are individual entitlements that fall outside the specific claims policy. The basic argument is that only claims brought by First Nations for a collective loss can be asserted. That's essentially the position of the First Nations in that claim, is that the termination of annuities to an entire band would make it a collective loss. And in fact, Canada's position in that matter was diametrically opposed to a position they'd taken in litigation, opposing a class action certification on the grounds that the right to treaty monies are collective rights or treaty rights, and only bands can assert those types of claims. But here we find ourselves before the tribunal arguing something completely different. In any case, to me, what strikes me about that is that if it was so patently obvious that the claim was outside the policy, why would it take extensive research and 7 years of review to provide a response that's saying, hey, you're in the wrong place. And you can't go to the tribunal, by the way, because this is outside of the jurisdiction of the tribunal, because it's not a specific claim. We took it there anyways, on the grounds that we believe the Crown is dead wrong on the point. So that is an example of a closed file, or a claim, and other claims that are, rejected on the grounds that there's no lawful obligation are not concluded at all. So now, my thinking is that if some 450 claims were rejected that were in the backlog, you would expect that lineup at the tribunal would be very long, that there would be 450 claims plus at the tribunal level. That's not happened. I think the only reason that's not happened is because although I view the tribunal as a kinder, gentler version of court, relaxed rules of procedure, relaxed rules of evidence, no limitation periods, lots of good reasons why First Nations should be able to achieve some sense of substantive justice or an outcome that is fair and balanced, but it's still expensive, especially the way litigation, almost any litigation, is carried out by lawyers on behalf of their clients. It's what I would describe as a war of attrition. There are motions after motion to sometimes suppress evidence, to exclude expert reports, to strike proceedings. There's a myriad of tools at the disposal of lawyers to delay and frustrate progress in a court or a tribunal. So in that sense, I don't think there's really a significant difference. So that is, I think, the problem in many respects is the cost of advancing the claims is prohibitive. So if we are looking at, the overall budget that is expended for the specific claims branch for that review process for a 3.5+ year waste of time at the front end, only to then have to do it once more with feeling before the tribunal and in an adversarial context, I would suggest that those resources would be better utilized at the tribunal level to assist First Nations in advancing their claims forward, so they can take them from start to conclusion in a relatively inexpensive fashion and in an expedient time frame. So in terms of the tribunal, I think the front end of the process is broken, but I view the tribunal as actually quite a success. I think it's It does provide for, as billed, the independent adjudication of claims. So in that sense, justice is not only done, but it's seen to be done, because First Nations have access to justice and the process is fair and balanced. No one party controls that process, and I think that that is extremely important. I don't agree that the problem lies with the tribunal at all. It's fulfilling its object and mandate. I think the problem lies in how Canada's callously rejected the majority of these claims, and with some impunity, I would say, likely with the full knowledge that First Nations simply don't have the resources necessary to be able to take it to the tribunal. So for all intents and purposes, they can characterize the claim as concluded if the First Nation lacks the wherewithal to be able to take it to the tribunal and have it effectively adjudicated. So, in my view, we need to build on that success. We need to enhance the power and ability of the tribunal to manage its caseload, expedite the resolution of claims, and fund First Nations adequately to be able to take on that task. The cost of expert reports and the process is staggering, so it needs to be addressed. And I think that that's the appropriate place to do it. So the pros, obviously it's independent from Canada, it's independent from the First Nations, it's not controlled by either party, tribunal can set its time frames, it's the master of its own procedure, as all tribunals are, can set rules with respect to the production of documents, hearings with elders on oral history, expert reports, written submissions, and final arguments, right? So the process can be efficiently managed because the tribunal has the ability to be able to impose time frames on both parties. The cons, again, it's still litigation. There are many procedural steps that have to be followed. It has to be done in a manner that's procedurally fair to both parties, so that means some rigor to that process, which can ramp up costs. Clearly not enough judges appointed to the tribunal, which means there will be delays in handling that caseload and writing decisions. As Justice Slade wrote in his last report, the tribunal will fail unless judges are appointed to it, so I think that that's a call to arms for the appointment of a full slate of judges to get the job done. Canada has also taken the position on a number of claims that submissions, research reports, expert opinions, all of the work that First Nations have probably expended $100,000 or more on the front end of the process are now not admissible on before the tribunal when you get there. So that means if you've got a treaty land entitlement claim where you've had to get very expensive genealogical and pay list analysis done by experts, you've got to start over because the position that work is all privileged. At least Canada, at one point, they were asserting that anything that went through the process, including archival documents, would be privileged. I think they've relaxed that stance. Now they would say any report that was done is not admissible either on the grounds of settlement privilege or potentially it's opinion evidence, so it's not admissible in its own right. So you got to do it all over again, as I mentioned, once more with feeling and at huge expense to the nation. So that's a significant problem. The war of attrition I've mentioned, again, you know, the tactics, I think, to really just delay or frustrate progress. One of the other things that I've seen as a matter of course is requests for bifurcation, which on the face of it sound pretty neutral and unoffensive. The idea being that we should determine liability first and then compensation. In appropriate cases, that makes a lot of sense. If a First Nation has to go to the trouble of getting expert appraisals done, loss of use studies, then you wouldn't want to incur that expense until the threshold issue of liability is being determined. But I think what I've seen more often than not is it really being used as, I think, as a tool to extend the process, to spin it out, to kick the can down the road ways. So even some of the claims that have gone through the tribunal process, like Kitsalis and Williams Lake, those types of claims have gone forward. They've been adjudicated. You have judicial review applications still on liability. That means after exhausting all of the judicial review and a potential appeal to the Supreme Court, they might have to go all the way back now into a process and try to negotiate a settlement. with goodwill and having considerably eroded during the last 10 years of litigation, and only to find themselves right back in front of the tribunal on a compensation matter down the road. So the potential for settlement could be 5, 10, 15 years in duration if we slavishly adhere to the idea of bifurcation. So I'm just going to sum up a number of recommendations then that I would suggest. First of all, I think it's pretty clear to my mind that the front end of the process is a failure. We should eliminate the concept of submitting claims for review by Canada entirely. I don't think it's necessary. All it does is it creates additional delay and cost for First Nations. It's also, I think, patently unfair because what it effectively does is it requires the First Nation to be a complete open book, disclose its entire legal opinion and legal theory to Canada in advance, gives them a sneak peek. If, they're rejecting 80% of the claims anyways, what's the point of going through that exercise? We should just go in front of the tribunal where it's balanced, file the claim, commence the process, provide all of your production in terms of documents, all of your expert reports, and at that critical juncture just before a hearing by the tribunal, I think that's the time when the parties should be encouraged to utilize mediation or non-binding forms of arbitration to potentially try to reach a resolution. I think that process would be much more informed if the parties come to their position through the process, use the process to inform your position as with respect to the strengths and weaknesses of your respective positions. The other problem that I see is that the idea of a Department of Justice legal opinion on the front end, on legal obligation or no legal obligation, has a number of undesirable effects. What I've seen as a matter of practice is that, first of all, it takes you 3 to 4 years to get that opinion. Once that Department of Justice lawyer, who is faceless, nameless, unknown to the First Nation, no level of scrutiny, might be a junior lawyer, might be somebody who's 20 years senior. Once they render that opinion, they have effectively painted themselves into a corner. I've seen instances at the tribunal level where the DOJ lawyer that has carriage of the file says, there's already a DOJ opinion that says there's no lawful obligation, so I have no mandate to negotiate with you at all. So in effect, they're kind of forced into taking an adversarial stance and defending the claim at all costs before the tribunal, and that's essentially all we're seeing. So getting rid of that and using risk assessment developed through the process would be a much more productive way of resolving claims. And I take some solace from the fact that in ordinary litigation, 95% or more civil claims are settled, usually just before a trial, on the eve of a trial, on the courtroom steps, but they're typically settled. Only a small number actually go to trial because the parties are usually prudent enough to want to avoid rolling the dice and taking their chances with a tribunal. A couple of other minor points. Eliminate the transitional rules for the same reasons as above. One instance of a First Nation in Saskatchewan, their claim was rejected 2 days before the Act came into force. They went through a very lengthy inquiry process, very complicated, multiple parties, and now they're being met with the argument that they have to resubmit their claim for another fresh review by the Specific Claims Branch. Again, what's the point? Appoint more judges, I've already mentioned that. Some work needs to go in to provide independent administrative oversight and operation so that the independence and neutrality of the tribunal isn't compromised unduly by political influences. And then the final recommendation would be to amend the definition of specific claims so that it's couched in broader terms. Avoid getting into specific categories of claims. I think it would be more productive to define it by what it isn't as opposed to what it is. if that makes any sense. You know, it should be based on broad obligations with respect to treaty, fiduciary duties, and specific claims, not Aboriginal title claims, but the nature of the remedy should be something that falls within the tribunal scope, and if they can award compensation for a breach of a duty, then it should fall within the claims process. And I'll just give you a couple of examples there. Again, Kitsalis and Williams Lake both went to the tribunal. The position of the Crown was essentially that because the First Nation was asserting a breach of fiduciary duty for failing to protect certain lands and converting them to reserve, that because that was based on unextinguished Aboriginal rights and title, it somehow went outside the scope of the policy. It doesn't. I mean, it's not a comprehensive claim. They weren't seeking to negotiate a treaty. They were seeking to obtain compensation for a specific breach of a specific duty. So I think a lot of work could be done in terms of fixing that and making it clear and framing it in broad and remedial terms. And those are my submissions. Thank you.
We talked about increasing the number of judges. The current framework is up to 6 full-time equivalents. That has not been fully staffed, and that's a problem right now. I think virtually everyone would agree to that. If you eliminated stage 1, and it seems to me it wouldn't be feasible just to stick at 6. If you eliminated stage 1 and all the action is at the tribunal, you probably need considerably more than 6 FTEs. One suggestion we've had is that provincial judges could be eligible to be appointed to the tribunal as well as Section 96 judges. Any thoughts on those?
I think that would be a welcome reform. In terms of the front end of the process, though, again, I just don't see any logic. I don't see any way in which that somehow facilitates or expedites the second stage anyways. So, when you end up at the tribunal, if you're starting from square one, as, Mr. Slavik mentioned, in one claim that he had, they were inundated with thousands and thousands of documents. The Crown had now taken a completely different position on their liability before the tribunal than they had in the earlier process. So all of the hard work over 20 years leading up to the tribunal, in effect, was right out the window, and you're starting from scratch again. So let's recognize that reality. Within that 20-year period, too, I'm sure the law has changed. So you necessarily have to modify your position in light of new developments, new facts that come to light. So, but I would agree with the basic principle that 6 is not enough. It probably needs to be greater than that, especially if adequate funding is provided to facilitate First Nations meaningful participation in that process, then that means they're going to need a larger contingent.
By way of background, the Williams Lake Band is a member of the Secwepemc Nation, and they're located in Williams Lake. Their main reserve is at the head of Williams Lake. And our firm has been working with the band over the last 2 decades to pursue its village sites claim. The band, and Chris was one of the key people who got this village sites claim going back in 1994 when the claim was first submitted to the minister and then rejected by the minister. And then they put it together and it was put to the Indian Specific Claims Commission, who did hold a hearing of this claim back in the mid-2000s, and a number of elders testified at that hearing. Some of them have passed on, and what came out of that Indian Specific Claims Commission hearing was a recommendation that Canada negotiate this claim and accept it for negotiations. That recommendation wasn't picked up on, and so in 2011 the band decided to pursue its claim before the tribunal. And as you know, and as a few of the earlier presenters mentioned, we were successful at the tribunal. We have an excellent decision from the tribunal, but that's not the end of our story. Canada has decided to apply for judicial review of that decision, and we will be before the Federal Court of Appeal on May 11th. We urge everyone here to come and show their support for the band as they continue to seek resolution of this claim. So what I would like to speak with you today about is about the band's experience in pursuing its claim before the tribunal, and to share some of the insights that we've had through that experience. And I'd like to talk about the good, the bad, and the wait and see. But first I want to start by saying just a little bit about what the band's village site claim is about, and to tell you that story so that you have some context. The band's claim is about its village sites at the foot of Williams Lake. Those were village sites that they had for hundreds and hundreds of years, and they were never protected as they should have been. These are places where the band's ancestors lived, where the band's ancestors were buried. And colonial laws required that those areas be protected from settlers, that they not be allowed to be preempted. And that didn't happen here. The band's main legal argument was that the Crown breached its legal obligations under colonial laws and colonial policies to protect the band's village lands, its Indian settlements. And we also argued that Canada inherited and remains responsible for those colonial breaches, and that Canada committed its own breaches after the British Columbia joined Confederation when it failed to right those wrongs. So what happened in this claim is that in the late 1850s and continuing through until the 1870s, settlers started recording preemptions to the band's village lands, even though, as I've said, the law was clear that Indian villages and settlements were not available for preemption by settlers. The band was pushed off of its lands, and as the band's chief Louis said when she testified before the tribunal, she said, "We were moved from area to area just like cattle." And other band's elders have said it felt like, and it was, the reality was that the lands were stolen from us. The places we used to be, we can't be there anymore. That's what the elders were saying. And the band's chief, back in 1879, Chief William, actually wrote about this problem, and his letter was published in the newspaper at the time, in the Daily Colonist. He wrote, "I'm an Indian chief. My people are threatened by starvation. The white men have taken all the land and all the fish. A vast country was ours. It's all gone. The land on which my people lived for 500 years was taken by a white man. He has piles of wheat and herds of cattle. We have nothing, not an acre. Another white man has enclosed the graves in which the ashes of our fathers rest, and we may live to see their bones turned over by the plow." That's the story of this claim. So as I said, this claim has two components. It has both a colonial component, the pre-1871 component, as well as a post-Confederation component. And we said that post-Confederation, Canada breached its fiduciary duties by failing to ensure that those village lands were protected and managed for the band's benefit, by failing to inquire to take any steps to have those preemptions canceled or set aside or quashed. And we argue that the Reserve Commissioner should have visited the band. They should have gotten there sooner, and they should have learned about their village lands. They should have investigated why it was that settlers were on the lands. And had Reserve Commissioners taken these steps, they would have learned about the importance of the village lands to the bands, and they would have learned that the settlers had actually taken those lands unlawfully. So, as I said, we filed the claim with the tribunal. The tribunal heard this claim back in, the evidentiary hearing was held in October of 2012. The legal arguments continued into 2013, and it issued a decision agreeing with the arguments the band had made. The tribunal accepted our evidence that the band had Indian settlements in Williams Lake at the time of the colony, and that the colony failed to ensure that the lands were protected from settlers. The tribunal also ruled that after Confederation, federal officials, knowing full well of what had happened with the band's land and their dispossession from those lands, failed to challenge the preemptions and instead let the settlers' interests trump those of the band. So this was a huge victory for the band, and they held a victory celebration in April of last year. It was a big, joyous gathering. We had neighboring communities and chiefs there, drumming, a big feast. There were members of City Council and the RCMP who were there. And that was a victory. That was reconciliation in that moment. It really showed that it was and is in the interest of all Canadians that these claims be settled, that the tribunal really can promote reconciliation in issuing a decision like this. But the decision is just one part, and that journey is not over for us. That reconciliation is not yet fully complete, because we will now, as I said, be having to defend this claim in the tribunal's decision in this judicial review. Canada is asking that the Federal Court of Appeal quash the tribunal's decision. It says it didn't breach any legal obligations to the band, but if it did, well, it gave them a reserve at sugarcane, and that should have fixed any problems there may have been. It also says the federal government shouldn't be liable for wrongs of the colony. So I want to move now to speaking about some of the good things that we've been able to realize through this claim, then I'll move to some of the bad and to some of the wait and see. So despite the fact that we are still waiting for resolution, there are a lot of good things that have been gained through the process of pursuing this claim at the tribunal. And the first one is the pace. For this claim, as I said, we filed the claim in October of 2011. We were at the evidentiary hearing a year later. And there were several case management meetings in the lead-up that did get us to where we needed to be, reviewing documents, making sure that the tribunal had what it needed to make sure that it could hear this claim. But there were no pre-hearing motions from the Crown to slow us down. There was nothing about needing more particulars of the claim, or nothing about trying to strike portions of the declaration, and very, very little about the admissibility of evidence. We had a very good document collection from when the ICC did its review, and almost all of those documents, without argument, were put before the tribunal as they should be. So that document collection is really the second good thing that happened with this tribunal claim. Because we had had such good work done before in the ICC process, we didn't throw all that out. We put that before the tribunal. Some of them were already transcribed, they had a good ordering system, all of that stuff that Canada sometimes uses before the tribunal to slow things down, to say, oh, it's going to take us so long to get the document collection where it needs to be. That wasn't the case in this claim. And we really did take the position that all of those documents that were before the minister when he rejected the claim and that went to the ICC, that is the claim. That's the story of the claim that also needs to be before the tribunal. This isn't starting new. We need to continue the process and build on the work that's already been done. And as I said, we did have a few discussions with Canada about particular documents that there were certain objections to, and we were able to resolve those and get those documents before the tribunal as they should be. And it's important because it does support the idea that the tribunal is just the latest step on this path. It's not a new path. And it means that these document processes weren't used to slow us down. I should say we did discover, as you do when a claim continues to evolve for as many years as this claim has, some additional documents that we felt were needed to be put before the tribunal, and we needed the flexibility to make sure that the tribunal had the best document collection before it, so we did have a few additional ones that needed to and that were put before the tribunal. The third really excellent piece about having this claim heard in the way it was before the tribunal was the community involvement. And that's a piece that even Chief Bear, who was just before you, was speaking about, the importance of making sure that the community's knowledge, the community's history, is heard in this claim, is understood in this claim, is taken into account. It's the community's story. So this idea that we see floated in Canada's parallel process, that maybe we can go and do paper hearings, that wouldn't have worked here. This is not a process for this claim that lends itself to a paper hearing. This is the people's story. And it's a story that is being kept alive in the memories of the Williams Lake people for generations. I mean, Chris here before we came up was saying, he's been working on this claim for half of his life, and he can't retire until it's over. And all of, he may be passing this work on to his grandkids, but that's also the feeling of the community members. They're passing on these stories from their grandparents. They're keeping this claim alive, and it was really critically important that the tribunal come to the community, hold a hearing. We held a week-long hearing. There were 7 community members, chiefs, past chiefs, spiritual members of the community, researchers who testified and who were given the space to give their testimony to the tribunal. And we had certain measures in place so that Canada would have notice of what would be said. We had a process of will say statements, and Canada also gave us will ask statements so that we would have some comfort in the kinds of questions they may be asking community members, so they would know that cross-examination would occur in a respectful way. Some of the witnesses chose to speak in the language, and the tribunal was open to that. We had a community member interpret for us. Some of the witnesses chose to affirm their testimony not on the Bible, but on other meaningful objects, on eagle feathers or on a rock, something important to them, and the tribunal respected that. I remember one of the elders who testified, she's now passed on, Mrs. Agnes Anderson, when the tribunal was swearing her in, she was a little bit hard of hearing and had a difficult time hearing what was happening. And the judge came right up to her, and she just looked him in the eye, and she said, I'm not going to lie to you. I'm not telling you stories. And that was accepted as her oath, and that's as it should be. These processes should be flexible to respect the way in which the community wants to tell its story, and we had that in this claim. And the fourth piece of the very good that came out of this hearing is obviously the tribunal's decision. The tribunal had a lot of issues that it had to deal with in this claim. It had to interpret and apply colonial legislation. It had to consider what is an Indian settlement, and did the band's village lands constitute an Indian settlement as the law understood it. It had to give meaning to the terms of union in Article 13, which says that Canada assumes the charge of the Indians and the trusteeship and management of the lands reserved for their use and benefit. It had to understand what it means in the terms of union, where it says that the colony's liberal policy will be continued by Canada. It had to consider whether the actions that happened post-Confederation, whether those were breaches of legal obligations. It had to assess the conduct that reserve commissioners had to be held to, and it had to consider what the Tribunal's Act says about pre-Confederation wrongs. And as I said, we think that the Tribunal reached the right decision on all of those issues. So I move now to speaking about some of the bad. First, it is an adversarial process. And although the tribunal's hearings are meant to be more flexible and to take into account matters of cultural diversity, pursuing a claim looks and feels like litigation. The lawyers for Canada are senior litigators. On our claim, we actually had the lawyer who represented Canada on the Tsuut'ina decision. That's who was pursuing this claim on behalf of Canada. They're well-versed in Aboriginal law, but they have a litigation mindset. We're not there to resolve the claim. They're there to win the claim. And that actually affects everything that happens before the tribunal. It doesn't matter if we're before federal court or before the tribunal. It can feel like you're in court. Thank you. Another one of the bad was last-minute theories. A week before we were supposed to start the hearing, Canada advanced a new theory that the band's village lands weren't actually in Williams Lake, they were in Chimney Creek. Totally new theory we hadn't heard before. The minister had this claim for 2 decades. Now, on the eve of a hearing, they're changing their strategy. We had to delay the hearing so that we could respond to these new theories. Same thing on Article 1. We'd made arguments about how Canada assumes the debts and liabilities. Suddenly, eve of hearing, we've got hundreds of new documents dealing with, what Article 1 of the Terms of Union really means. Same thing, 2 decades, this is the first we've heard of it. The third bad, deny, deny, deny. When you get the declaration, when you file a declaration of claim and get the response back, you get things like, the Crown doesn't know if any of the members of the band are or consider themselves to be members of the Secwepemc Nation, so we deny this paragraph. We get responses like, we deny or we don't know if the band traditionally occupied settlements in the area around the city of Williams Lake. This is exceedingly vague and irrelevant to the matters before the tribunal. It's formal stuff in litigation, but when you're the band and you receive that, it's deny, deny, deny. The fourth of the bad is delayed resolution. We still are waiting for resolution. We had a rejection from the minister, we had a recommendation from the ICC, we have a good decision from the tribunal, and now we're going to the Federal Court of Appeal, and who knows after that? I mean, Chris is thinking, well, I don't know if I want to get on a plane to go to the Supreme Court of Canada, but that may be where this ends up. Delay, delay, delay. This is a long time to be pursuing this claim. And the tribunal was promised as a way of delivering finality, but that's really elusive for now. The fifth bad point is insufficient funding, and a number of the other speakers have spoken about this. The funding received to pursue a claim before the tribunal is really insufficient to cover even half of the costs. And it's a huge access to justice problem. And for the band, it just feels like it's whittling away the limited resources that they have and really hampering their ability to pursue the claim. Just before I close off, I want to touch on a few of the wait and sees. Wait and see number one is, what is the tribunal's authority for pre-Confederation claims? That shouldn't be an issue here, but Canada's making it an issue. We're saying the tribunal continues the previous policy where Canada said as of 1991 that they would hear and accept for resolution, except for negotiations, claims arising from colonial wrongs. Well, now they're trying to bat that out of the tribunal's jurisdiction. The other wait and see is, well, we're waiting for finality. We know that the Canada does have the right under the Act, under Section 34, to pursue a judicial review, but should it be this very broad judicial review, challenging all aspects of the tribunal's decision? Is that what was intended here for this final decision-making body? The third wait and see is really how do we pave the way for resolution here? Will these claims, these settled claims, these good decisions be used and applied in other negotiated situations at other tables to help those claims also be resolved so that we don't all have to be here before the tribunal? The fourth is funding for the tribunal itself. We've heard this a number of times. They don't have the complement of judges they need to hear these claims. They don't have the resources themselves. We've birthed this thing, but we haven't actually given the tribunal what it needs to do its good work. And Judge Slade has made numerous calls for more resources so it can do what it's intended to do. And I'll conclude just with the 7 recommendations coming out of what I've just said is, number 1, provide funding and resources to First Nations claimants and the tribunal throughout the process. We have no funding to pursue the judicial review, to defend that judicial review that Canada's brought. 2, keep claims in the community. The tribunal needs to see the lands. The tribunal needs to hear from the people. 3, ensure the claims are heard in a timely way. We can and we did do that with Williams Lake. 4, don't throw away the work that's already being done. Use it like we did with the ICC's work. 5, the tribunal's jurisdiction to hear claims should line up with Canada's long-standing policies. Shouldn't be narrower than that. 6, the parties should be encouraged to keep the goal of reconciliation in mind throughout the processes. And 7, the final one, the tribunal should be empowered to develop a body of law that helps with the resolution for all claims.
The approach we've taken to looking at the Act and related policies is what we're calling a principles-based approach. In this presentation, UBCIC will draw on the principles as articulated in Justice at Last that animate and are reflected in the Act. We will focus on how we can ensure that these principles are respected, implemented, and carried through in the tribunal's processes, and in the way that the parties act and behave throughout those processes. Overall, we support actions or amendments that promote rather than limit flexibility, and that limit rather than support unilateralism. As an introductory point, we note that although the Act was passed in 2008, the tribunal didn't open for business until 2011. So while it's time for a 5-year review in legislative terms, we must be mindful of the fact that the tribunal itself has not been operating for 5 years, nor is it yet fully operational since it doesn't have a full complement of judges. As a final note, it's our understanding that Mr. Pelchat's report will be submitted to Minister Valcourt, who will then use draft his own report and to table to the House of Commons. It is imperative that Mr. Pelchat's report be made public to ensure transparency, openness, and accountability. I'll turn it over to Leah for a bit.
So I just wanted to flag some of the principles that we see reflected in the Act, and then Jody and I will both flesh those out in our subsequent comments. So the first principle that we see throughout the Act, and peppered in the preamble in particular, is resolution. It's lasting resolution that's in everyone's interest. And we see that in the preamble, the very first paragraph there. It's in the interests of all Canadians that the specific claims of First Nations be addressed. And then we see the word resolution and resolve used 5 more times in those paragraphs. We know that the tribunal has a mandate to decide, to resolve those issues of validity and of compensation. We also see the principle of reconciliation. Resolving claims will promote reconciliation between First Nations and the Crown. We see the principle of independence, the need for this independent tribunal, the call that First Nations have made for so many years to get out of a biased system and to have this independent third party. And we have judges now so that it does away with the inherent bias of the past processes. We see the principle of distinctiveness. The tribunal is designed to respond to the distinctive task of resolving and adjudicating specific claims. And why is it distinct? These are historical claims. The facts go back, in many cases, over 150 years. Sometimes the historical record, the documentary record, is incomplete, and the First Nation has oral history to provide. They deal with complex legal issues. It's also distinctively about the Crown-First Nation relationship. We see the principle of choice. It's the First Nations' choice to access the tribunal. I think that's a principle we'll speak about a little bit more. The Act only affects the rights of First Nations if they choose to avail themselves of the tribunal. We see the principle of access to justice. It's the First Nations' choice to access that tribunal. Access to justice plays into the need for proper funding and resourcing as well. We see the principle of promoting negotiations. The preamble says the tribunal is here to create conditions that are appropriate for resolving valid claims through negotiation. See the principle of lawfulness. These claims are to be adjudicated in accordance with the law. An emphasis on justice and fairness. The tribunal is to bring greater fairness to the process while accelerating the settlement of claims. That's from Justice at Last. And we see in the preamble to the Act that the claims should be adjudicated in a just manner. The principle of timeliness. Instead of letting claims go on for years and dealing with all the plague of delay, that fuels frustration, that fuels uncertainty, these claims are to be resolved once and for all by the tribunal. They should be adjudicated in a timely way. See the principle of flexibility, and that the tribunal has the power to make its own rules, and it has done so, along with the help of the Rules Advisory Committee, of which the Union and Department of Justice is also a member. We see principles of finality and certainty. The decisions are supposed to be final and conclusive between the parties, subject only to judicial review. And we see these principles being picked up in some of the decisions that we're getting from the tribunal, like the Tsleil-Waututh decision and the Holalt decision. So Jody and I now want to move to applying those principles and offering some recommendations on how we hope these principles can be carried through in all of the work that the tribunal does and the work of First Nations before the tribunal. So the first principle, resolution, I want to just read from a decision that Justice Whalen made in Tsleil-Waututh. And it touches on the point of resolution. He says, there's a national public interest in reconciling the historical tensions between Canada's First Nations and the larger Canadian community by means of a fair and timely resolution of specific claims. He goes on, the goal is to resolve and reconcile tensions, perceptions of injustice, lingering frustrations that have evolved as a result of unresolved specific claims. And we really need to keep that in mind in everything we do here. We shouldn't be engaging in processes that just make those tensions worse or create more perceptions of injustice or more bars to resolution. What we need is an attitude shift on the part of Canada, a shift from we have to win this claim to we have to resolve this claim. And that can have ripple effects when we're dealing before the tribunal. The parties can focus on the real issues that are engaged and hopefully won't be sidetracked by approaches that delay or obfuscate the actual issues. The second principle, reconciliation, we need to move forward in a good way that allows us to put the past behind us. And if we are really serious about reconciliation, we need to figure out a way that lets us do this with every single step of the process before the tribunal being focused on that aim. So do delay tactics assist in reconciliation? Does taking away a First Nations choice as to how to advance its claim assist in reconciliation? Do last-minute theories or quasi-admissions assist in reconciliation? What about stopping First Nations from amending their declarations of claim? What about barring First Nations from making arguments grounded in the honor of the Crown? Does that assist reconciliation? What about objecting to the admissibility of a First Nations oral evidence, or requiring that that evidence be put through in a voir dire? Does that assist reconciliation? We have to make sure that the goal of reconciliation is brought to bear in all we do. And we also need a considerable demonstration of trustworthiness on the part of Canada. It'll take a leap of faith for the First Nations to actually engage in this and believe that reconciliation is the goal and not just more adversarial processes.
Thank you. We also want to talk about the principle of independence. We all know that the tribunal is established to ensure that the process of adjudicating claims will be fair and impartial. Claims will be decided by independent, impartial judges and not by the federal government itself. But now we know that the tribunal's registry is being moved and is coming under the Administrative Tribunal Support Services of Canada. Independence is central to the work of the tribunal, and we fear that this move will harm its independence, certainly in the eyes of First Nations. What we don't want to see is the tribunal's processes come more and more under the purview of the federal government. On review of the Minister's engagement paper, we're deeply concerned that Canada is contemplating increasing the administrative duties of the tribunal, for example, the administration of research funding, claims being filed directly with the tribunal while simultaneously undermining its independence and authority by having those administrative duties managed by the new umbrella tribunal support service instead of an independent tribunal registry. So with this in mind, we urge that there be commitments to ensure the tribunal's institutional independence independence and restore an independent registry. Back to you.
On the principle of distinctiveness, as I've said before, these claims, they represent a story, and they're stories about how the federal crown has failed to protect bands' interests, failed to respect or uphold people's way of life, failed to keep treaty promises, and these stories are still alive and the wounds are still there. So responding to the distinctive task of adjudicating claims requires seeing the lands and hearing from the people. And this is consistent with one of the principles of fundamental justice, the right to be heard. And the communities have waited a very, very long time to be heard and to see justice be done. We have to maintain that. So processes like having a view of the lands at issue are critically important. Claims can't be decided from a desk in Ottawa. You have to be on the land and you have to hear from the people. We don't want a paper system that takes the people out of the claim. And respecting distinctiveness also means accepting that there's no one definition of oral history and there's no one way of advancing a claim. We don't want to be engaging with Canada on processes of a templated oral history protocol with pre-existing ideas of what it means to present your own story. It should be up to the First Nation how to present their stories and how to advance their claims. Ultimately, the tribunal has to have flexibility so that it can hear from each distinct First Nation advancing its own distinct claim in a manner that respects its distinctiveness and their choices.
So with that in mind, the Act is premised on a First Nations choice, and the tribunal only has a role if the First Nation chooses to file its claim there. To us, this means that the First Nation has to be in the driver's seat in terms of how its claim proceeds. Canada has consistently stated that negotiations are its preferred way of resolving claims, and we agree. But allowing Canada the option of referring a claim to the tribunal would mean that First Nations are, against their will, dragged into an adjudicative process that can be both lengthy and costly. Or if Canada has the option of referring claims to the tribunal, First Nations may be barred from accessing the tribunal from the get-go. This is an option that would have meant out more acrimony to the process and will not foster reconciliation. In terms of access to justice, the number of claims already filed tells us that there is a desperate need for the tribunal. We know that there's a long line of claims waiting. Some First Nations are choosing to wait either because they cannot afford the costs not covered through funding agreements, or because they're waiting for a decision in a similar claim, hoping that a positive decision will lead to a negotiated settlement. Further, First Nations must be properly funded in order to access the tribunal. To date, the funding provided is barely covering 60% of the legal expenses associated with pursuing a claim before the tribunal. Canada, on the other hand, appears to have ample resources, as up to 3 lawyers and a paralegal have been assigned to certain claims. This unevenness in terms of resources is unacceptable. The other access to justice issue is tribunal resourcing. Although the Act states that the tribunal is composed of a roster of 6 to 18 judges, it currently only has 3 judges, and only one of them is full-time. The tribunal itself noted, without the appointment of more judges, the tribunal's chair warned that the tribunal will fail. As a final point, we note that there are serious concerns connected to research funding and the funding for First Nations to take their claims to the tribunal. Both come from the same pot. The Act stipulates that claims can only be filed with the tribunal if they previously have been filed with the minister and if they meet a minimum research standard. In other words, claims must be well researched and documented in order to reach the tribunal. Because research and tribunal funding come from the same pot, funding for First Nations to bring their claims to the tribunal will have a direct adverse effect on research funding. In fact, First Nations tribunal funding will be at the expense of research and development funding in a cycle of diminishing returns. The more claims that the tribunal is forced to hear because Canada will not resolve claims through negotiations, the less money there is to conduct the research necessary to advance claims to the tribunal. We therefore recommend that these 2 parts of the process be fully resourced from distinct funding sources. I'd like to talk a bit about the promotion of negotiation. The Tooth decision stated the legal principles developed and applied by the tribunal are intended to offer a framework that will facilitate resolution, not only through adjudication, but through negotiation, which may hopefully reduce the necessity of litigation. An important role served by the tribunal is to clear impasses in the Crown First Nation approach to the understanding of a claim, and thereby open the door to negotiated settlements. The tribunal was never intended to hear every or even most claims. The tribunal was never intended to help Canada avoid negotiating settlement agreements, but rather to be a tool for First Nations to compel Canada to negotiate claims. And yet we know that Canada is closing the claims submitted to it and simply forcing First Nations who want resolution of their claims to go to the tribunal. Tribunal decisions are intended to and must inform negotiation tables. Tribunal decisions need to be respected and implemented. They need to be binding on Canada. Canada should not be arguing that factual differences between claims mean that the legal principles articulated have no application. Further, First Nations should be able to request that their closed or rejected files be reviewed in light of tribunal decisions. When asked, Canada should be compelled to engage in the second review that does not force First Nations to enter the claims review process from the beginning.
In light of the time, I'm just going to make a few more comments and then pass it back to Jody and to Grand Chief Stewart Phillip. But the next principle is lawfulness. And the tribunal does have a role in bringing rule of law to the relationship between First Nations and the Crown. The tribunal is there to apply legal principles. We have those legal principles in decisions like Garin and Willicum and Manitoba Métis. The tribunal is doing that same job of applying that law, and that law that's developed through the tribunal will continue to be developed through the tribunal, as Jody said, should assist in resolving other claims. The principles of justice and fairness, those are very big and very important concepts, but they can also be difficult to articulate in the abstract, and they tend to show themselves more in the breach. So we know that we need to have proper notice of the claims, we need to have an opportunity to be heard, we need to have access to an impartial decision maker, and we need to know that the decision maker is acting in good faith and without bias. And we know that First Nations are coming to this process with fairness and justice having been denied to them for a very long time, and that is a very critical, important background. We need to make sure that there's processes to account for that, to make sure that fairness and justice is there for First Nations. We don't need page limits to the amount of argument you can make before the tribunal or the types of arguments you can be advancing. We don't want bars to the admissibility of the evidence we choose to lead. And on the next principle of timeliness, we need to figure out a way to get to resolution faster. We don't want to use all of these tribunal processes, the CMC, the case management process, just to delay hearings. We don't want judicial reviews of every single positive decision that comes out of this tribunal. That's not the kind of resolution, that's not the kind of timely resolution we were looking for.
A very quick note about timelines, but I'll save it for the written submission, really. But just the Canada's approach to the 3-year timeline as an operational model has created a lot of problems, whereby INAC negotiators are tabling so-called final offers, which have little chance of being accepted by First Nations, just to close a file before the end of a 3-year period. All these claims could have access to the tribunal and further compound a lot of the things that we're talking about. Did you want to talk? Okay. So just as a final point, we wanted to talk about the idea of finality. This is a big thing that Canada likes to talk about publicly, that we need finality and certainty. First Nations want finality. They've been seeking resolution and finality for a long time. They don't want to keep going on the merry-go-round of processes. Each new process prolongs and delays finality. Canada's version of finality includes final lowball, non-negotiable offers, sometimes only on a portion of their claim, and a demand for release on the rejected portions. Peter Havlick spoke well about this morning, so I won't say more. But our opportunity and our challenge here is to get to finality in a way that respects other principles that we've discussed. What we'd like to see is effective, respectful processes that work towards true resolution through negotiations and that allow the tribunal to perform its intended function, to make final and binding decisions on specific claims when meaningful negotiations fail.
Haskahot, Ipisiinaksiu, Hinchaya Squeeze, Asiut. I'd like to begin by acknowledging the Coast Salish peoples, namely the Tsleil-Waututh, Squamish, and Musqueam. And I'd also like to express on behalf of the Union of BC Indian Chiefs our appreciation and gratitude to the Assembly of First Nations for providing the opportunity for this important conversation. I would also like to express my genuine appreciation to all of the presenters up to this point who have offered some very compelling and powerful evidence in regard to the bad faith represented by the specific claims process as has been experienced by our First Nations communities throughout the last several years. I recall clearly when the Specific Claims Tribunal Act was first announced. I remember the sense of hope and optimism that we had finally achieved a process and a way forward to resolve the multitude of outstanding specific claims across this country, and had reason to believe that we were on our way to finally bringing about closure to these issues that span, in many cases, hundreds of years. Specific claims and the resolution of specific claims represent a very important opportunity for our First Nations communities. Without question, First Nations communities, Aboriginal communities across this country are in a state of crisis. The statistics, the social statistics around the increase of internal violence, domestic violence, gang violence, the issue of missing and murdered women, the lack of adequate housing, crumbling infrastructure, homelessness, massive substance abuse issues that are prevalent in many of our First Nations communities are prime examples of the gaps that continue to exist and widen with respect to the Indigenous peoples of this country in terms of being provided with adequate resources to address those issues with respect to health, education, economics, and so on and so forth. In that regard, specific claims offer the opportunity with respect to the hundreds of millions of dollars, if not billions of dollars, that are tied up as a consequence of Canada refusing to not only acknowledge but act on its outstanding legal obligations and follow through with their public commitments to resolve in a very expeditious fashion the whole matter of specific claims. Unfortunately, the Specific Claims Tribunal Act and the process has proven to be anything but expeditious. Rather than seeking to resolve specific claims, the Government of Canada has chosen to obstruct, to deliberately obstruct the honorable resolution of these outstanding legal obligations. I believe the Specific Claims Tribunal Act would have been more aptly named as a Specific Claims Coliseum Act. The very fact that it has taken every opportunity to simply and deliberately mislead the general public in terms of shifting files from one basket to the other and announce publicly that they have been very successful in dispensing with the backlog of specific claims, when in fact we know that exactly the opposite has occurred in terms of the increase in files. The fact that when final decisions are made, they have completely violated their commitment and promise and have sought judicial reviews in the case of decisions that went in favor of First Nations. So there's little doubt that the Government of Canada is not committed to resolving these legal outstanding obligations to First Nations. Rather, they're absolutely committed to obstructing our efforts in spite of the incredible work that our research centers across this country and our specific claims people have dedicated to these files for, in most cases, for many decades. Our efforts are frustrated. I think that the 2007 Senate Standing Committee report on specific claims, negotiation, or conflict or confrontation as Canada's choice pretty much says it all, given what these specific claims represent to our communities insofar as providing resources to address the appalling socioeconomic conditions in our community. And as a consequence, the future looks very grim in regard to specific claims issue. I agree with the presenters that this is an important issue, not only for First Nations, but for Canadians in general. And without question, the conflicts at Oka, Ipperwash, and Caledonia were a direct consequence of unresolved specific claims. And I have personally been involved in those types of conflicts and confrontations, and I know there's an enormous cost in terms of unraveling those conflicts, far beyond what it would cost the Government of Canada to act honorably and justly and follow through with their public commitments. Quite frankly, with the current government in power, I don't see any hope. In spite of the fact that this exercise here, I think, will serve to inform our leadership, our people, and the general public as to the truth of the matter, I believe that there is no honor in the current government, and we will continue to go down this rabbit hole of sharp dealing, bad faith, and dishonorable conduct. So it's, I find that to be unfortunate, but I believe that to be the reality of the situation.
Very quickly, one, this is a review of a piece of legislation which is a set of rules, and some of the good news that's been reported back is because the rules were pretty good. Like the business about cultural sensitivity was written right into the statute and is written into the Rules of Procedure for the Specific Claims Tribunal Act. So the rules, the letter of the law matters. I think some of the success that's been reported, it's not universal, but there's been a lot of positives by the tribunal, a reflection of rules that set it up institutionally, established its dependence, directed it to be culturally sensitive. But one point I want to make sure, at least I've heard loud and clear, is rules don't mean much unless you look at two other things, which is who's applying them and what resources they have to apply with. So you can say, well, tribunal's doing some good stuff, give it more of a role, but if it's not independent, or it doesn't have enough staff to do its job, then the rules aren't really going to do much good. So I would expect that one of the things we'll be thinking about is how to make sure that the rules are accompanied by the resources and the staffing to actually make rules effective. Second, with the formation of the rules, several people have mentioned the change to consolidate the tribunal with the rest of the administrative apparatus of administrative tribunals. My understanding that was done in an omnibus bill, was part of a budget cutback. There was no separate notice, there was no process in which First Nations were engaged to discuss that. One of my concerns about this process we're engaged in right now is, are we falling into a mode where we just make suggestions and the federal government disposes? One of the things I think that led to successful rules, personally, was that there was that engagement, that the AFN was at the table with Government of Canada, and a lot of the good stuff came as a result of that engagement. No matter what we recommend, I think its prospects of being effective are a lot less if it's just here's our thoughts, now you decide, rather than a restoration of the dialogue, which I think led to a lot of the progress. And just one other point, we heard in Toronto, and we've heard again today, that this process isn't suitable for all kinds of claims. And that's unquestionably true. I mean, for one thing, this federal government is not going to agree to claims above $3 billion. Right now it's $150 million. We heard in Ontario there's certain kind of claims that just aren't suited for it. It was suggested today that maybe another process would be better for agricultural benefits claims. I don't see those as either ors, right? We can have a solid specific claim system, and there can be additional options created in addition to, as a supplement to that, and First Nations will have their choice as to where to go. So I don't see any conflict between this concept that maybe some claims really could be handled by something even better versus doing our best to improve this as the default option for when those other processes were available. So anyway, very quickly, those are some of my thoughts on what we've heard so far.
I was actually happy to hear about and we continue to hear about the good points of the Indian Claims Commission and the work that they did and what that led to in many instances. And a quick question to Leah. You mentioned that there's at least a question raised that should Canada be able to refer claims to the tribunal in their own right without the consent of the First Nation, and your position was clear that they should not. Can you just expand on that a little bit and set out the reasons why you think that's not a good idea?
What we're saying is that the tribunal is there to give First Nations the choice as using that as a venue to resolve their claims. We don't want this to be used by Canada as a punitive measure on First Nations, forcing them into a tribunal process that they're not resourced for and that's not their choice of how they want to resolve their particular claim. So we think that principle of choice of First Nations having the access, as opposed to Canada saying, well, we want to take it here just to show that this claim doesn't even fit within the boundaries of what our policy is or what the Act should be doing. We don't want to have it be used that way as a punitive measure to be barring First Nations from resolving the claims the way they want to.
So with the theft of our lands, we did put together two different submissions. The first one was rejected right away, and then we submitted another one, I believe in 2007. We started working on it, and we went through that ICC process. And they also rejected on technicalities, saying that Chief Neskonlith technically did not have the authority to set those stakes out. And even though our elders have oral accounts of the history of that, and also of the different background and context to using our land and occupying our land, and also how the whole story unfolded. And a lot of that, even though they recognized a prima facie of the lands being used and then continually used and occupied, they still denied our submission. And so we were rejected twice, and the whole system I believe is not able to handle our mega claim. Our claim is over $150 million, and they pretty much in the whole system, we either go to cabinet or to court. And I believe if we went to cabinet, we don't even know what kind of decision would come out of the cabinet when we do put our claim forward. And with the tribunal, the way the system is set up right now, and not funded and not a very good process to go through, a lot of our community members didn't have faith in that tribunal system. And the way the specific claims is set up, it's a very flawed process overall. And we felt that we wanted to have a fair and just process, and we don't believe Canada, under their existing comprehensive claims policy or their specific claims policies, will give us a fair justice. Our community at Neskonlith, we've done numerous submissions to the United Nations, and some over our Sun Peaks at Coquitlam, one of our mountains, sacred mountains, and we've done other human rights submissions. And we'd like to also recommend that the AFN, after these hearings are done, that they also consider filing a submission to the Human Rights Committee in July in Geneva. We feel that
not only does Canada have to be told the truth, we believe internationally our Indigenous people, our United Nations have to be told the truth, what's going on in Canada, because it is unacceptable in this day and age that they have racist, genocidal policies such as the specific claims and the comprehensive claims. We are presenting to the United Nations the Special Rapporteur on March 31st about the comprehensive claims. So we felt that the specific claims has a lawful obligation on part of the Crown, and it does have to measure up on how it lives up to the honor of the Crown, and it has failed to meet legal obligations and implement the constitutional principle of honoring the Crown, and that's on page 3. So, and I believe the previous leaders did touch on a lot of the issues we were going to present on, and we also talked about the international. And I'd like to just say that the Union BC Chiefs supported us by calling the federal government to recognize the Neskonlith Douglas Reserve and to act in accordance with the honor of the Crown by re-establishing our Neskonlith Douglas Reserve, and they submitted a resolution in 2007. We also had one from the BC Assemblies of First Nations. But also one comment I wanted to make is the post-Chilcotin decision. I believe that this whole specific claims process now doesn't even follow some of the new Supreme Court law, or even some of the past 150 different cases that we won. They maintain a territorial concept of Aboriginal title resulting from that declaration of title, and I don't believe that is being taken into account with the specific claims or the comprehensive claims process. They're talking about renewing CCP, but not on the basis of those laws. And I believe with specific claims, it has to be reviewed and changed in the era of post-Chilcotin. And we have to be able to look at the new laws, and Canada needs to implement its own laws, and it hasn't been doing that. Just the recommendations following the international one, we recommend the removal of limitations in terms of size of claims and remedies that can be brought before the tribunal. We stress that the necessity of appropriate funding for specific claims research be reinstated but increased. We note that the greater of the claim, the greater injustice, hence the need to address mega claims in an immediate and wholesome manner. Canada's laws and policies in regard to specific claims have been brought in line with international human and Indigenous rights standards. If the tribunal and federal government are unable to address our specific claim, the area should be immediately declared Aboriginal title land, since it was set aside for the exclusive use of our people.
As things now stand, there's no roadmap for claims over 150 million, right? You couldn't go to a federal document or a flow chart and say, okay, it's over 150, this is how we go to cabinet. Is that correct?
About 4 or 5 years ago, we attended a specific claims conference here in Vancouver. We weren't on the roadmap. We went there expecting to see something. So they wrote it on the edge, and they told us we only had opportunity to go to cabinet or court.
Our process is basically started back in 1995, and our claim is specifically to do with boundaries and how they were measured back then, leagues versus miles. But we're also one of the original signatories of the Robinson-Huron Treaty of 1850. So it took up in 1884, that's when they came out and surveyed our community and never talked to our chief at the time or anything, and it just got surveyed. And we have a very small community, and it's 2 miles by 2 miles what it exists today. So the leagues issue, and we identified that it should have been the leagues, so which would have brought it 6 miles by 6 miles, so 36 square miles, as opposed to the little postage stamp that we have today. So with that said, the claim is based on the incorrect survey, but in April of 2000, the Department of Justice began a legal review of the claim, and this is just a bit of background. In December 2000, the Department of Justice, they validated our specific claim. So in January 2002, the claim committee terms of reference was adopted, and in May 2002, ONS informs Wahnapitae that it had no basis to participate in our claim, which is a province, because it was prior to them even existing. So that's their excuse for not coming to the table. And in September 16th, 2002, Minister notes correspondence further states about the province and it wouldn't be at the table, and how it wasn't sure how it would be able to give us the land back, because now the land is under the jurisdiction of the province. And again, that's where I still have problem. You know, our claim was based on that, and our negotiations were going along really well with the federal government. And then when the Conservative government came into play, that's when the problems really existed. And we were getting there, we were really negotiating some good grounds with the government at that time. And in part of the negotiation protocol, it was called good faith negotiations. Here's a concern I have with good faith negotiations with the Conservative government. Well, there is no negotiation on their part, because they don't want to negotiate. And that's one of the biggest problems we have. You know, after our claim was validated in 2001, the Greater City of Sudbury amalgamated 10 of the municipalities, or the unorganized townships, which surround our First Nation, and we've had a claim. We notified them, we put them on notice, as well as the federal government, provincial, and municipality, that these lands were in question, and we have a claim against them. So, and as things progressed, we moved on, and then and I'm going to try to move things up a little quicker here. So, and we did do a loss of use studies as well with the federal government delivers at that time. So back in, as things progressed, then in November 2009, that thing stopped for a while, and it and this all had to do with waiting the 3 years for the federal government to get back and let us know that whether they were going to put us on a tripartite or on a tribunal, or whether they would negotiate. Instead, in 2013, we got in 2012, March of 2012, we got one of the letters in the mail, a take it or leave it offer. So, and it wasn't, we feel it isn't fair. You know, we were negotiating, it should have been negotiations.
And you expressed your concern that people might accept it because of the fact that they need the money. And you're quite unhappy about it, obviously, because you thought circumstances, you were in a better negotiating position before this period.
Yeah, well, that's correct. And the other thing is when we went to the table to meet with the federal government after we received this letter, we were told we couldn't even negotiate. And right now, where the claim stands is with the two lawyers to negotiate, because we have issues with the ATR process as well, addition to reserves, and how that may affect, and we know what the processes are and how long it takes. And then we need to have somebody willing to sell this land, which now we have to deal with the province as well as with the municipality. You know, there's also the thing is if we don't have anybody there that wants to sell them, and I know that the money that they put on the table isn't even going to be enough to purchase that land, let alone compensate some of the members for this as well. You know, so I'm very disappointed, and I know of some of our other treaty communities that belong to the same treaty, and some of the negotiations they got to negotiate with, but we have never got an opportunity to negotiate with this Conservative government.
Okay.
the dissatisfaction with your negotiations, or the offer anyway, and that you don't think that the tribunal would be effective. Is that because the tribunal can only award money, or is there another reason that you think that the tribunal wouldn't be effective or a good route to go?
The reason I believe is, sure, we're going to get compensated some money, but the real issue here is the land that we should have had in the first place. First, we don't feel that we should even have to purchase this land back. We feel it should be the federal government that should be giving this land back. We've already negotiated with the federal government prior to this, and we already came to a conclusion before the Conservatives identified the land. They were in agreement. What we were going to do was do the loss of use, and then the Conservative government got elected, and then everything changed.
We've had a lot of input about take or leave it offers, so maybe you can just give us the level of specifics you're comfortable with. Is there a time limit on those? Do they say take it or leave it by such and such a date, or this is off the table?
No, we had a short amount of time to respond back in regards to this take it or leave it offer. We were told if we didn't respond and if we didn't come back to the table, that we would be taken off the table and put wherever we would be put on the list, or we would never get a chance to bring it back to the table. That's my understanding of what happened.
Okay, and did the take it or leave it offered, they're always accompanied by a request for releases. Did they ask you to release a whole bunch of claims beyond the one you were actually submitting?
I haven't seen that part in the agreement about releasing anything, so I can't comment on that.
Okay, thank you very much.
We've been involved with specific claims for quite some time, and we received a letter from the minister asking if we would negotiate on a couple of our claims. We're in a really unique situation where I come from, which is in the Gitsan territory. Gitanmaax is situated, the way our reserve is set up, we have a couple of municipalities around us. So when you look at our reserve, unfortunately, due to the actions of the Indian agents of the day, we have patchwork. I call it patchwork. So down in the municipality of Old Town, you will have X amount of lots that are reserve. Then you will also have land that is municipal, surrendered, unsurrendered, sold, not sold. It's a mess. It's a mess. And we have all the documentation, we've got all of the information. The whole process was approved. But the challenges that we've been dealing with, and the gentleman prior to me speaking raised a couple of them, and one of it is monetary. We've told the government time and time again, monetary is secondary to us. We're really connected to the land, and a couple of the claims that we're dealing with, history, our ayok, our traditional processes have been impacted by the taking of that particular parcel of land, and it's a huge parcel of land. And that's what we were trying to reiterate to the government, that this is not about money. And if we had it our way, we would just want to have the land back, because we are growing, our population is growing and our land base is shrinking. Gitanmaax's specific claim is presently in negotiations. We had put it in abeyance as per the minister's request to go into negotiations. And over the past few years, it's been really, really frustrating, because it will take months and months and months for our responses to the government to be responded to. And the last time that we met with the government representatives, we ask why the whole process is being drug out, why the whole process is taking so long. And it's because of staffing, they say, or people are moving, people are changing jobs, or budget cuts. And that's on the federal Crown side. To date, our community, for the one specific claim that we're dealing with that has to do with the Hazelton municipality, those dollars have come from us. So one of the questions that I asked in our last meeting was all of the financial resources, time and energy that the First Nations expend on the process, are those all taken into account when you talk about a settlement? Because if hypothetically they're offering me $1 million and I added up all my bills and I spent 1.5 over the last 25 years dealing with this specific claim, I'd have to tell them to just keep their money, just give us the land back, because we would be on the losing end. Our finances are on the losing end, plus we lose the land as well. I think with the specific claims, any land that has not been sold, it should be returned back. And we've raised that issue. They keep telling us that that's not an option, that money is the only option that we have. And we really have problems with that. The second claim that we're dealing with is quite a bit more complex than the first one. The second claim that we're dealing with, other people live on that land now. And we don't want to create any ill feelings or hard feelings amongst the people. We've asked the Crown, how do we sort that out? Because the history of that land has to be told. The fishing holes, the hunting grounds, all of that information has to be told. And history gets lost when people don't know the truth. And the taking of that huge parcel of land was done by the Indian agent of the day. And there wasn't any consultation, there wasn't any involvement of the community people at all. It was all done behind closed doors. So in that regard, the scope of the specific claims, if all they're wanting to deal with is monetary compensation, it goes beyond that, because you're affecting people's lives, you're affecting not only the history but the cultural fabric of what makes those people come together. And there's a huge part of what's missing from the Gitanmaax people, with that huge area being taken away and now having other people live there as their own, claim it as their own. When I'm in negotiations with the school district, I most often believe and I feel that I'm dealing with rational people who want to negotiate in good faith. While I may disagree with or dislike some of the positions that they've taken from time to time, at least I understand why those positions have been taken. I'm dealing with a rational person. However, when I'm dealing with Canada in the specific claims process, at least since the Justice at Last policy was implemented, I most often believe I'm not dealing with a rational party. And that gets really frustrating. It gets really frustrating. And I think part of the problem is that people aren't truly understanding where we're coming from when we're talking about the land. And I used an analogy in one of our sessions that if I came to Vancouver and I moved into your home and I just shooed you and your family out and said, I'm going to be taking this over, here's $100,000. I said, you would have major problems with that. I said, here nobody has any major problems taking our land away. Nobody. And they think that money is going to solve the problem. It doesn't solve the problem. All of the delays that Canada has with regards to the entire process is outrageous as well. The one-size-fit-all approach doesn't work. You've heard throughout the day different presentations, and there's been descriptives on how that process doesn't work, because it doesn't, the melting pot doesn't work. I don't want to take up too much time, so I'm going to go right on to some recommendations that I hope might be of some help. Canada, and this is odd for me to be saying this, but it's because we've been at this for over 25 years and we're spinning our wheels. Canada should make more funding available to hire more negotiators, or at least more in BC region, in order to try to resolve the large number of claims rather than shifting those resources towards litigation. Many of the delays that have been given to us from the Crown have been lack of human resource, time. So maybe if more was provided for them, we'd see things moving a little more swiftly. It's Canada's present course of action just means that it would continue to shift its resources to litigate with us at the Specific Claims Tribunal and in federal court. More funding could mean better settlements reached more quickly and in a more pleasant manner. Canada should also provide more autonomy to its regional negotiators to craft settlements which recognize that the one-size-doesn't-fit-all approach to settlement, and it causes more problems when you try to utilize that type of a formula. One of the stumbling blocks that we have encountered in both of the claims that we currently have is when we have had meetings with the Crown which were far and in between. They always had to go back east. They always had to go somewhere else before they could give us an answer. So that was one of the first things that I had asked before we entered into negotiations. What was the mandate that those individuals had? And would they be able to make even small decisions if possible, because they can't make any. The people that we're dealing with here in Vancouver, they can't make any decisions. I'm seeking more power for Canada's negotiators and lawyers. It's almost humorous that I'm doing so. But if our mutual goal is to truly do reconciliation rather than going to court, then something has to change. Regional negotiators need to be empowered to work closely with us to craft settlement agreements which respect that not all of our communities are the same. Rather, there are major differences, and we cannot have our settlements dictated through Ottawa. And that's what's happening right now. So if I was to go, which I am next week, to do a presentation to our membership, and I did say this to the Crown 2 weeks ago, the way it is right now, my recommendation, but it's not up to me, but my recommendation would be not to agree with it. I wouldn't agree with it. But ultimately, the decision rests with the community, but that will be my recommendation to the community. So in conclusion, I'm hoping that some of the solutions or potential solutions, advice and guidance that's being provided by the First Nations, that it doesn't sit somewhere on a shelf. I've participated a few times in different opportunities like this, and often things don't really come to fruition, and it creates a real sense of hopelessness at times when you're trying to do right by the community and you're always hitting blocks. Those blocks need to be moved so that we can move forward. And all the wrongs that have been done, they just have to be fixed. It's so simple. It doesn't have to be complex, drawn out, and expensive. The government did something wrong, they just need to fix it, and let's move on.
When you say that you don't feel you have somebody rational to talk to on the federal government side, is that because you're getting no reasons for their position, or you just get something repeated over and over again, an instruction from Ottawa, or they don't have authority to give you a reason? From what you're saying, this disagreement in and of itself is not necessarily creating bitterness. It's more that you're not feeling you're having any kind of meaningful dialogue. So just if you could just explain it just a bit more.
All of the above.
All of the above, okay.
No, truly, it is.
I understand.
Yeah, all of the above.
Okay.
Grassy has had a couple of previous specific claims which were settled, but these were the types that went on for 25 years. They were very frustrating. I was the lawyer on both of them. They were dragged out. The relationship was very bitter. The members of the First Nation who were at the table, the chiefs, councillors, negotiators, I think over time they were just, in a way, they were just crushed. It was so dispiriting to deal with the federal, and in Ontario there's usually provincial people at the table also, but it was so hard. They went through so much and for so little, not necessarily in terms of money, although I'm not referring to money at all, I'm just referring to satisfaction. They worked so hard, they were so dedicated, and after 25 or more years, they just said, well, was that really worth it? It was just so hard. Now, that was true that they managed to get settled. The third one, and that's the one that I want to use to illustrate some points of issue and recommendations here, is one that's before the tribunal. So these issues that I will refer to are issues that relate to the tribunal. And I know that the terms of reference of the panel are much broader than that, but this is fairly focused. The one that I'm talking about is a claim in respect of highway land that was taken across the Big Grassy Reserve. Whereas the two specific claims that I mentioned that had been settled, they were claims that arose out of situations where white interests were at stake. So they had a little bit of leverage and could get, after 25 years, as I mentioned, they could get some kind of a decent settlement. But in regard to this highway that was put across the reserve, no white interests were at stake. The land had been expropriated. This community didn't really have the resources to go to court and fight the legality of the expropriation. And so they're basically at the mercy of first the negotiating process and now the tribunal.
merely to get compensation. You took our land to pay us. And this was one of the ones where the take it or leave it lowball offer was made. Here's what we'll offer, and if you send us a BCR by such and such a date, we'll send you a check. If not, we're closing your file. Goodbye. So, despite its weak situation, this offer was so dismissive that Big Grassy decided we'll go to the tribunal. We'll try it out. The tribunal was just getting up and running at that time. Just a couple of quick factual points about the claim. I mentioned that it was a expropriation. There was a route for the highway expropriated in the 1933, and then it was expropriated again along a slightly different route in 1941. No compensation was paid for the first one. The compensation for the second one was $224.70. So you can appreciate that this is a claim of modest size, and that's to be generous. But nonetheless, it was so dismissive that the First Nation thought, well, we've got to go to the tribunal. It's just not right to not go to the tribunal. And with some degree of optimism. I should say right at the beginning that the First Nation has no complaints about the operation of the tribunal, none. But nonetheless, a whole series of problems had arisen, and they are attributable, quite frankly, to the way that the Crown conducts itself before the tribunal. So I'll just step through them. There are 10 items here. Some of them are interrelated, some of them you've heard a lot about. The first one is whether the tribunal is restricted to what Canada previously agreed to negotiate. In their claim, I mentioned the 1933 expropriation, the 1941 expropriation. Within the specific claims process, Canada had agreed to negotiate the 1933 expropriation because zero was paid, but not the 1941 expropriation because $224.70 had been paid. Anyway, the position of the Crown was, well, because we only agreed to negotiate one of those, you can only take one of those to the tribunal. And the reference was to Canada's so-called validation letter. But we observed immediately, and did so, that why does the Crown say that absolutely everything from the negotiations is privileged, except what we think is not going to be privileged, and why they wanted to walk that distinction between the two into the tribunal. Now, I don't think that there's, in fact, I'm sure that now we're 3.5 years in and they're no longer taking that position. But this matter should be dealt with in a general way, I suggest. And the recommendation is that in cases where there's multiple related claims, but they all arise out of the same facts, and Canada has rejected part and accepted part in the specific claims process, provided they all arise out of the same facts, I would suggest that the tribunal should be empowered to take them without facing basically a jurisdictional question, but whether there is jurisdiction there. In other words, the First Nation, the claimant, can look at the parts of its claim that had been rejected and say, well, do we want to continue with this, or do we accept that we're not going to succeed on it? Or do we want to take it forward? And if they decide to take it forward, that is the claimant, they should be allowed to. And then the tribunal can just deal with it as part of the claim. So I'm suggesting that it would be wise that that be generalized in some way, because it will arise, and I think it has arisen in other cases. The second issue that we identify here is where a specific claim has included information about damages, but the practice is, I think this is quite true generally, that when specific claims are submitted into the negotiation process, very little is included in them about damages, including theories of damages, specifics of damages, and so on and so forth. But in the Big Grassy case, the Crown at one stage at least, early on, was saying, no, if you didn't particularize the damages that you want in the negotiating process, even though that's supposed to be privileged, you can't bring any new variation on your damages claim before the tribunal. As I said, they're not taking that position any longer, but I think it would be very wise if there was some way of getting that formalized, because it's just fair that it should be that way because of the practice. Otherwise, First Nations putting together a claim in the first instance are going to have to spend a lot of time and money figuring out their damages theory and getting their damages particulars together, which is a very expensive and time-consuming process, whereas the initial question, of course, both in negotiations and before the tribunal is liability and not damages. The third issue we identify here is where there are damages caused by private parties. Perhaps we mention this just because it's so farcical, but in the Big Grassy case, there were a bunch of non-Indians who went and built garages along the highway that had been expropriated with no compensation, and they say, well, we should have been paid rent, or the Department of Indian Affairs should have shooed those people off. They were not on the right-of-way, but on the reserve. But the position of Canada was, well, there's nothing to stop you from suing those people. This was in the 30s. This was in the era of Indians as wards of the state. This was in the era when the Indian agent was in control of everything. This was in an era when people at Big Grassy were not literate. They'd have to travel through the bush a long distance even to get near a courthouse. And when they got there, well, of course, there was the prohibition in the Indian Act at that time, effectively making it impossible to hire lawyers. So all of those factors simply make it farcical that the Crown should take this position. I'm not sure exactly what the recommendation is here, but just to illustrate that there seems to be no benefit that could possibly be gained for anyone when the Crown takes positions of that type, and yet they are taken seemingly routinely, and in this case they are. And I think I'll say more about that in a minute. The next issue that we've identified is the question of liability of a province. In Ontario, as I mentioned, quite often the provincial government is in the picture somewhere, and in this particular case, the provincial government's in the picture because it's the provincial government that wanted the land so they could build their highway. Under the Act as it is now, the tribunal can notify the province, do you want to come in? In the case of Ontario at least, I don't know about other provinces, but I think it's fair to say that Ontario is not going to and never will turn to this particular tribunal. Maybe they'll change their position. But when they don't, you get a situation where Canada is able to, in effect, make a third-party claim without the third party defending. So the First Nation is put in a situation where it kind of has to defend a third-party claim, even though it may not even believe that it should. So my suggestion is that the tribunal should somehow be clothed with the ability to say that if what Canada is doing with respect to a province here, it was in court, and it could in court or would in court be properly characterized as a third-party claim, then they can't do it. They can do it in some other form. If Canada wants to sue Ontario and say, we want your share of what we had to pay to Big Grassy First Nation for the highway, let them do it somewhere else. Don't force the First Nation to bear the burden of that in the first instance. The only qualifier on that would be that the claimant would have to at least establish some liability in Canada. Next issue we identify is burden of proof. Canada went to horrendous lengths in our small case to try to get the tribunal to agree that, as a general principle, the claimant bears the burden of proof. Now, we had to fight it tooth and nail, and we succeeded, but it's not a decision that is necessarily establishing a principle that will be followed in every case. So we think that it should be made explicit, and that is that when you have a situation where the Crown has kept all the records, and in many cases kept them very poorly, and had arrogated to itself the power to do everything, and kept the First Nation out of the loop, why should Canada, in the 21st century, many decades after the fact, come to the tribunal or be able to come to the tribunal and say, well, notwithstanding that there's barely any record of what happened, and there's obviously a highway through your reserve, but you can't prove very many of the facts, because the facts do not appear in any of the files that we failed to keep. It's just, it's wrong in terms of general principles of onus. Now, members of the tribunal can deal with that, of course, on a case-by-case basis, but we suggest that it would be desirable if that principle might be addressed in more general terms, and I would leave it up to you as to how you might do that in any recommendations you make. But to simply have as a general principle that when a claimant comes in the door, the claimant has an onus of proving everything from day one, and the Crown can just sit back and say, prove it, when the Crown has had control, basically, over whatever evidence might have been available. That's not fair. Next issue, well, we say something about funding. I think I'll skip through that. You probably heard about that. Compensation. Now, as I mentioned, we've got a First Nation with a reserve in the Boreal Forest. Strip of land there is not going to be worth very much, but the damage was not what's the value of a piece of land in the middle of the bush. What happened to the community is that it was split in half and radically changed. Now this puts us into questions of how compensation is awarded, and I'd like to point out the conflict between what is in the Act in paragraph 21E, that compensation for that kind of loss is not to be awarded, and what the Supreme Court of Canada said in the Assayas case about cultural component that is important in Indian land. Also, I'll mention that even the Department of Aboriginal Affairs Land Management Manual takes into account cultural component of valuation of land that's taken, but the tribunal is not to do that. So the recommendation, and it's not actually in the paper, but I'll make it more specific. Everything in Section 20 of the Act after sub C, I suggest, should be eliminated. It's all this pretzel-like stuff about if it was legally taken, then you get this kind of compensation. If it wasn't, you get that kind of compensation, and so on. Everything after sub C, I think, just doesn't make much sense. And in particular, that part about cultural and spiritual interest of the First Nation. Next issue, material from the negotiations. Canada treats claims that come before the tribunal as if they appear on a blank screen from nowhere, whereas they've got huge files from negotiating. Why can't at least the sets of historical documents be presumed to be the initial part of the record? Why can't even expert reports come forward? And I know the tribunal might have to deal with that on a case-by-case basis, but there should be at least a presumption that you don't waste all the time and effort that went into the negotiations in terms of documents and reports and just pretend they don't exist and do them all again. It's silly. Issue number 10, we've used the expression waging lawfare. The way Canada operates within the tribunal process is essentially the same way as well-financed defendants operate in court, and I've dealt with that in non-Aboriginal cases a lot in my career, and there are, I suppose, reasons for it in some cases, but I don't understand the reasons for it in the case of specific claims. These decisions of the tribunal are not binding, they're not appealable. The worst case scenario is Canada may have to pay a little extra money. But surely that is a small price for not creating just bad blood that will go on forever and people say, boy, that was just a horrible, horrible experience. One major recommendation, we now have an independent tribunal. It took 50 years to get, more than 50. The recommendation is that Canada be represented by an independent entity, which it could create in cooperation with the AFN. The reason why it's suggested here is that there's just baked-in attitude within the Department of Aboriginal Affairs and the Department of Justice, not the people, but the institutions, and if you could get it to one side, create an office of some kind that deals with these things, possibly also on the negotiating side, it would all work a lot better in my humble submission, our humble submission. Maybe it's wishful thinking, but it took 50 years to get to the tribunal, maybe a few more years and get an independent body created and confirmed, of course, by the Crown, but that represents the Crown. Just a couple of things. I'll mention 5% twice. 5% of cases that are even commenced in court, less than 5, actually go to trial. We know that's a frequently quoted number. Also, insurance companies, in a lot of their lines, they budget 5% for administration and litigation and 95% for paying claims. I know for many years, I don't know if there's any recent numbers on this, because things are so secretive, that Canada was paying more for negotiation and litigation and administration of its claims process than it was paying out in claims, which, although they're not the same, they're similar enough that you have to say there's something wrong with this picture.
Thank you very much, and for the very specific suggestions. Just on the last point, that's quite a remarkable figure. Where would we find that? As I understand, we would be looking for transaction costs versus actual costs of settlements, and you say that they're actually paying more to fight and argue than they are to settle. Is there some place we could go to actually verify that?
I had those numbers from, I have to confess, quite a few years ago. And I haven't looked recently, and so I can't help you. I wish I could, and you know what, I'm going to go away and see if I can find that again. But if I look, it would be into old numbers, and I'm not sure, but it may be that the information that's released now is no longer in such a form that you can break it down and get an answer on that.
Okay, thank you very much.
One question. The idea, if I understand you correctly, what you recommended is the outsourcing of legal and negotiation representation for Canada. So it will be done by an independent third party. Is that what do I understand correctly?
I'm not sure. It may be that it would just be a office that's attached to a different department of government, some intergovernmental affairs entity, as maybe a tiny step towards recognizing and accepting what First Nations have been saying so strongly and for so many years, that you have to stop treating us like we're problem people to be managed and start treating us like nations. So it would be sort of like that. Now, I'm not suggesting that Canada be denied the opportunity to be represented in the way it wants to be represented. I'm saying that it shouldn't go through the existing institutions and departments that have so demonstrably failed.
I'd like to focus first on the specific claims side of things.
The Canada's action plan articulated in Justice at Last was really to retool the specific claims process in order to bring justice to First Nations and certainty to all Canadians. It proposed to do this by resolving historic grievances cooperatively through negotiation. Instead of setting up an independent commission to deal with the process, what has been set up is a tribunal. Given the objectives of both of the action plan and the process guide, the question really is, has the retool process resulted in grievances being dealt with through more cooperative negotiations? Have claims and the claims process dramatically improved and enhanced the processing of claims? In my experience, the reality is quite the opposite. In the province of Saskatchewan alone, which I'm most familiar with, in 2008, when the Tribunal Act came into force, there were 70 outstanding claims with specific claims. Since that time, only 1% of those claims have been settled. 72% of those claims have been concluded either through rejection, file closings, or litigation. Of the claims considered, quote, negotiated, most of those have been, as mentioned by previous presenters, take it or leave it offers, or there have been lengthy delays awaiting mandate approval for the negotiators to even present an offer. Any concept of meaningful and good faith negotiations have been undermined by funding cutbacks to not only the First Nations, but also within the department. Face-to-face negotiations have been basically eliminated due to travel restrictions, and federal negotiators have limited mandates to negotiate anything but predetermined compensation figures. There's no funding made available to First Nations for the negotiations except if they accept a settlement. So there's no negotiation funding up front to the First Nations if there's going to be any idea of negotiations. The offer is take it, leave it offer. We will provide negotiation funding and compensate you for negotiations if you agree to a settlement. Mandates for settlement offers seem to be held hostage also by some political expediency. We've heard many cases where we are reluctant to settle a particular claim, the election's coming up, you're going to have to wait until after the election. The current focus of claims resolution appears to be to punt really validation and significant compensation issues to the tribunal rather than to really deal with them through negotiation. I think the sad irony is that while the superior courts in Canada, the Supreme Court of Canada, are encouraging the reconciliation of claims through negotiated settlements, and you have the specific claims policy, which advocates the settlement of claims through a process of negotiation, what you have is a process where the emphasis on litigating the claims to a resolution. The current specific claims process, in my view, appears to be gutted through various administrative, financial, and maybe even political means. Its original political objectives have been really lost. I'd like to just spend on the minimum standards also. Some have spoken a little bit about it. Claim submissions are, as you know, are required to meet certain minimum standards before they can be filed with the minister. And the department has the discretion within 6 months to decide whether a claim submitted has met the minimum standards. The First Nations that I've been involved with have found compliance with the minimum standards have now been excessively and unnecessarily onerous and costly, leaving the department with the discretion to determine what claims will be filed or not filed with the minister. With claims funding cutbacks, compliance with the minimum standards has been proven difficult, if not costly, impossible to meet in terms of the costs available and the finances available to get submissions into the system. It's my feeling that the tribunal should be given the mandate to exercise some supervisory or monitoring role over the determination of whether a reasonable minimum standard has been met for claims to be filed with the minister. After all, it's going to be the tribunal itself at some point down the road possibly that's going to be making a decision about whether the documents filed before them is going to be considered in the merits of a claim. I want to speak a little bit about the mandate of some of the federal negotiators. The federal negotiators really only have limited mandates confined basically to predetermined positions taken. They are really, as mentioned by others, messengers of a settlement that has been decided already. There are really no meaningful negotiations that take place at all. Even if there are some kind of negotiations that actually takes place, it's very difficult for the federal negotiators to change their point of view and their mandate without having to go back to Ottawa to reconsider their mandate. There's very little flexibility in their negotiations. Furthermore, because of federal cutbacks, they are unable to meet. In fact, we've been told at most they are able to meet maybe once or twice to negotiate. Otherwise, negotiations, if you want to call them negotiations, are dealt with out of Ottawa through conference calls. Mediation. The action plan itself recommended mediation to achieve negotiated settlements. Access to the tribunal would only be after all other avenues have been eliminated. One of the avenues in the action plan that was suggested was utilizing the Indian Claims Commission to facilitate and mediate negotiated settlements. Of course, that hasn't taken place. We understand that there is a mediation roster and a mediation process within the Department of Indian Affairs, but it has been rarely utilized. I don't think it's been utilized at all. In fact, we approached the Department of Indian Affairs and suggested mediation in one instance. Once they saw this request for mediation, they were totally caught by surprise. There was a lot of uncertainty on their part of what to do, if anything, on how to proceed. It's my suggestion that any mediation services are a valuable claims resolution process and should be made available, but independent from the Department of Indian Affairs. Either as part of the tribunal process or some independent process set up. I'd like to turn my attention then just to the tribunal. The mandate of the tribunal, as you know, is to hear and deal with issues of validation and compensation brought by First Nations where the minister has decided not to accept a claim for negotiation. The tribunal does not have the mandate to hear rejected claims, accepted claims. It's only rejected claims. What I've experienced is that in claims where there are multiple allegations, some of which have been accepted for negotiation and others that have been rejected for negotiations, when the matter proceeds to the tribunal on the rejected part of the negotiations, in other words, the claim has not been accepted for negotiation, the Department of Indian Affairs has decided to close the file and all allegations are to be dealt with in front of the tribunal, forcing the First Nation to deal with all allegations before the tribunal, including those which they previously accepted for negotiation. I think the Act should make it clear that the tribunal only has the mandate to hear rejected claims, not those where the department has already accepted the claims for negotiation. There are transitional provisions that really permit the First Nation to resubmit a claim if, in fact, it was a claim that was rejected prior to the Act coming into force. What has happened is that there's some uncertainty on the part of the department whether they would fund claims that had previously been rejected. What has also happened is that any claims that have been resubmitted are treated by the department as first-time claim submissions. These are not considered as claims previously resubmitted, but you start from square one as a resubmitted claim. It would be my recommendation that the tribunal should have the mandate to review these resubmitted claims to determine if the submission and supporting documents are essentially the same as previously submitted and decide whether the First Nations claim should be filed directly with the tribunal based on the previous rejection, instead of having to go through the whole specific claims process over again. If this resubmitted claim is significantly different from what had been previously submitted, then the tribunal might make a determination that this is a matter that should be refiled with the minister, but it would be a decision of the tribunal itself. I have concerns about the adequacy of funding to the tribunal itself. This has been raised by others as a concern. There's inadequate financial resources for the tribunal to deal with the existing caseload. Inadequate number of Superior Court justices have been made available to deal with the claims before them, and these claims are only going to increase over time. In terms of funding the process as well before the tribunal, claims funding has been primarily by way of a contribution agreement to the First Nation based on a work plan and a budget that's been submitted. But often the claims funding is inadequate. It's difficult to anticipate when you're in the tribunal process what costs are going to be involved. Are there going to be demands for particulars? Are there going to be issues of documentation, evidentiary record, elders' testimony? All these issues come up procedurally, which need funding. One-time funding, the funding by way of a contribution is only on an annual basis. If there's any funding left over, the department requires the funding to be returned, and you have to make a new submission. And even though there are a number of matters that need to be dealt with before the tribunal. Judicial review, I just want to say a few words about that. Presently, the Justice Department has the opportunity to judicially review any sort of errors that are made, factual or legal errors that are made, and they have, in fact, proceeded with judicial review applications. This has imposed a huge burden on First Nations who don't have the financial resources to deal with the judicial review application. There should be funding available to a First Nation if there's a judicial review application made by the Department of Justice. And even if the First Nation itself wants to proceed with a judicial review application because of some errors, factual or legal errors, they should adequately be funded as well. I have comments, other comments that I will leave to my paper itself. At the end of the day, I feel the question is really whether the Specific Claims Tribunal Act has been adequately resourced and whether specific claims and the process itself is going to survive the limitations that have been imposed on it. The federal government, I believe, has to seriously reconsider litigation as the preferred approach to the resolution of specific claims. If such is not the preference of the federal government, then First Nations need to see a commitment to meaningful and effective improvements to the claims process that actively involves First Nations collaboratively and cooperatively with the department in the submission, consideration, and negotiation of specific claims.
Two things struck me. One, the tribunal should decide whether or not the minimum standard is met, and previous rejections should count, and if the claims are substantially different, then it would be up to the tribunal to decide whether it should be refiled with the minister.
Correct.
Those two things lead me to suggestions that other people have made, and which is that even with those measures, it would still be better if there was no phase one at all. In other words, the tribunal would receive the claim. It would decide whether, for its own purposes, for its own process, a standard has been met, and previous rejections would automatically count. What's your view on the wisdom of that?
I have concerns about phasing out phase one of the process. I believe strongly in the need to negotiate the resolution of claims. I don't think it's really in the interest of First Nations to end up in front of the tribunal on all claims that are dealt with. I don't think a litigation process really engages First Nations. It's primarily a litigation and legal process. I think negotiation really involves the engagement of First Nations more in the resolution than through a litigation process.
As far as I can figure out, the operational federal policy on what they do at stage one can only be inferred from conduct. You cannot find a public record document which says, for example, we only accept a claim if it discloses lawful obligation, we don't do risk assessment, we fight everything till the end. There's really no place we can actually figure out what the marching orders are for any of your counterparts on the other side. Is that right?
When an acceptance letter is provided to the First Nation, there's sometimes reasons given for the acceptance. So there is the rationale. It's not detailed. It's not provided there's no detailed evidence or evidentiary record of how they went about reaching that conclusion. They do provide some indication of the reasons why they accepted the claim for negotiation. The problem is, if in fact the claim is accepted for negotiation, or if the claim is rejected for negotiation and the rationale is given for both, it's all presented on a without prejudice basis. And if you proceed to the tribunal, none of that can be admitted. And that leads a problem in front of the tribunal as to what was the basis on which a claim has been accepted or rejected for negotiation. Because to get to the tribunal itself, you have to demonstrate that there's been a rejection. And it's the letter, but they say you can't submit the letter because it's without prejudice.
So if you get one of those, you made 8 claims, we accept one, we reject others. Is that something you take to the tribunal and say we've now got 7 rejected claims? Or
what they do in the one claim I had where that was a scenario, the First Nations indicated that they were prepared to negotiate the claims that had been accepted for negotiation, or the allegations that had been accepted, and just proceed to the tribunal on the rejected portion. They were notified that because the matter now on the rejected portion was before the tribunal, they were going to close the file and they were not going to negotiate the claims that had been accepted, forcing the First Nation now to deal with all the allegations, including the accepted ones, before the tribunal.
Just a couple other quick ones. Has there been any, to your knowledge, any experience with using the mediation services at the tribunal stage? It's theoretically possible. The rules allow for another tribunal member to act as a mediator. Have people tried that yet?
On the validation side, of course, there's very little room for mediation but I don't know of any claims that have reached the compensation stage where mediation has been offered as an approach. I would like to see mediation offered along the way, even on the validation portion of the tribunal hearing, because during the course of submitting the claim, preparing the common book of documents, preparing all the evidence, sometimes there's evidence presented that wasn't really considered by justice previously. So they should have the opportunity to reconsider their position. But right now, their instructions are to litigate all the way with no instructions to consider any alternative way of resolving the claim.
And again, it's something that we would infer from the way they act. It's not a stated policy to fight everything to the end or not to use mediation. It just has to be inferred from what actually happens in the real world.
I've been told by justice that's their instructions.
Oh. Well, you would not, we wouldn't find a public record.
I don't think they disclose a public record of that.
Just one last thought, you understand, I have to respond to it. If you had only one stage, which was one where you file your claim with the tribunal, I'm just thinking aloud here, it doesn't necessarily preclude a robust negotiation part. That is, because if all claims begin with being filed with the tribunal, nothing to stop the parties from negotiating it rather than proceeding to go ahead to a hearing in case management and so on. They could go to mediation. They could say, let's agree to take a break for a year while we try and work this out. There's a concept of rolling the negotiation period into stage 2. Does this seem to have any prima facie feasibility, or is it better to keep the two stages independent and distinct?
Are you talking about bifurcating the two?
I'm talking about, what if you only had one stage? All claims begin with filing in front of the tribunal. And you were saying, yeah, you have some concerns like litigation isn't the ideal, and everybody, I think, agrees with that. But if you started by saying we start with a claim, it seems to me still possible to build into that process, which is all under the management of the tribunal, substantial ways you can negotiate. There would be the mediation facilities of the tribunal. Both sides can agree, before we go ahead with any further litigation, let's try and see if we can spend a year working this out. The whole theory of the Tribunal Act, of course, was if you have an effective tribunal, it'll promote negotiations. So far, that hasn't happened. But if you roll it all into one, it seems to me that it could be done in a way in which you still have lots of room for negotiations. This isn't a detailed proposal, I'm just thinking aloud here, but it seems to me that rolling into one solves a lot of problems like minimum standard and replication of evidence, not having to use experts' reports. So if you can keep, and it does allow room potentially for negotiation and mediation and so on and so forth.
I would think if things are rolled into one stage, and during the case management process, there's an opportunity for the parties to consider different ways of resolving it. That might be worthwhile considering, but right now the instructions to justice are not to consider any alternative way of resolving the dispute except going straight to a hearing.
Tseshaht has a number of specific claims, including illegal taking of water. We are one of the few reserves in BC that have a lake entirely within our reserve. There was water that was taken under water licenses illegally from the lake without our consent or even our knowledge until relatively recently. There's a train right-of-way. There's a claim for the illegal move of a reserve boundary. One of the boundaries of our reserve, it appears that the marker was moved, effectively making the reserve smaller. There's a claim for the illegal expansion of Order in Council 1036 roadways, a claim for illegal surrender of a roadway, a claim for illegal placement of a foghorn on the reserve, a claim for an illegal right-of-way, a claim for a logging road right-of-way, a claim for the loss of an entire reserve, a claim for improper logging of a reserve, and related claims for negligent administration of banned assets. So you can see that Tseshaht has a very broad spectrum
of claims that they're going to be putting before the federal government, and some of them have already been put before the government. None of the claims have yet proceeded to a hearing. We're continuing to research all of them, and actually our researchers just informed me 2 weeks ago that we may have yet another claim as well. They've uncovered documentation in respect of improper logging on a reserve and the possible pocketing of some of the money by the then Indian agent. So, in addition to all of those, we have some historical claims for the loss of Tseshaht villages. When Port Alberni was being established, there were a number of Tseshaht villages at the head of the Alberni Inlet and at the mouth of the Tsuut'ina River. And as they began to establish Port Alberni, I guess the good citizens of Alberni didn't like looking at the Aboriginal people, so they moved us and kicked us out of the village at near the bottom of Argyle Street. And then as Port Alberni expanded, they kicked us out again from Nlaka'pamux village and kicked us out a third time until we finally get to where we are today. The result was the loss of approximately 6 village sites by Tseshaht. All of that was contrary to the then policy of the colonial government. They were not to remove Aboriginal people from their communities. So we've got a broad spectrum of claims for roads, loss of water, improper administration, and some historical ones as well. The point I'm trying to make there is that Tseshaht is dealing with a very large number of claims and a very broad spectrum of claims. The rest of my submission to you will be about the policies of the specific claims process, and I'd like to identify some of the issues as we see them and perhaps make some suggestions as to how we can change things. I'm sure you've heard some of these already. I'm positive you have. But perhaps the more voices that say it, the better. And secondly, I may say some things a little bit different than the way others would. So the first point I want to make is to echo the words of the court. This should be a process of reconciliation. The whole idea is to reconcile Canada's past wrongs and what happened to the Aboriginal people. And it's my respectful suggestion to you that this is a very important aspect, because when Canada chops the funding for the research and for the ability of the poorest people in this country to advance claims against the government, they have the effect of exacerbating or making worse the original wrong. So Canada illegally takes a reserve from us and then makes it illegal for us to advance claims for decades through legislation, and then chops the funding from us to research that claim today. I suggest to you that the effect of that is to exacerbate the original wrong, to make it worse now for the people now than it even was in the beginning. It also has the effect of making the wrong more acute, in the sense that we must now come up with some of the funding to pursue that claim and use the funding that we would otherwise use, as I said earlier, for children's programs or other members' programs, to try and research our position with respect to the government wrong. So I say it accentuates the wrong, it exacerbates the wrong, and Canada is not living in the true spirit of reconciliation with Aboriginal people. So Tseshaht believes that the whole specific claims process was originally intended to be a roadway towards reconciliation. But what gave rise to the wrongs was a shameful past for Canada. We say that the way that Canada handled the Aboriginal people's issues up until modern time was a shameful legacy on the part of Canada, and it should be viewed that way. The current process that Canada has now brought in does not
invoke reconciliation. Quite the opposite. It invokes an adversarial relationship with the Aboriginal people. Canada is putting this issue with Aboriginal people on a table of adversity, and it doesn't belong there. It belongs on a table of negotiation and reconciliation. That's where it should be. The previous claims process was long criticized as being time-consuming and unfair, and it was. Claims were taking decades, even just to be responded to. And I think a lot of Canadians look through the lens of only today. They can't do that. They have to look through the lens of Canada's historical treatment of Aboriginal people. And my respectful suggestion to you would be wrong for your committee not to reflect on how Canada made it illegal for many, many decades to raise money to pursue Native claims. And often when those of us who sit on council talk to the general public, they'll raise their eyebrows and say, why are you raising this now? It's so old. Why now? Well, we couldn't pursue these specific claims for decades because it was illegal to raise money. So I think that looking at Canada's conduct today in respect of this, the specific claims process, you really have to look at Canada's conduct today through the lens of the history of the Indian Act and attempts to squash Aboriginal culture and government and deprive Indians of Aboriginal people of the right to get counsel and pursue a claim. So I won't go through it, some of the history of how we get to today at the bottom of page 2. In 2007, of course, we got the invocation of Canada's policy, you all know, justice at last. The most significant part was the establishment of the Specific Claims Tribunal. It was set up to expedite claims and avoid lengthy court process and hopefully avoid an adversarial situation that you find in court. The number of cases are ballooning. Just in my tribe alone, the 11 cases that we have. And when we looked at why are the cases ballooning, we believe that the reason rests in the lap of Canada. It's the rejection of all the claims despite the application of principles from previous rulings or from rulings of the court. Canada has policies which preclude a negotiation, such as a policy of not considering what they think are minimal claims. In the 2007 policy introduced shorter timelines for processing the claims, but it's not working. The current process continues to be adversarial. It continues to be time-consuming, overly time-consuming, I should say, and continues to be extremely costly for First Nations. That has been exacerbated again by the dramatic recent cuts in funding from the federal government. Research and development of these claims are an important part of the process seeking a fair and a just resolution of the claims. It's important that First Nations on the road to reconciliation be provided with the funds so that it becomes a fair process. Specific claims funding were cut in half to $4,330 and $5,350 for legal. These dramatic cuts have required Tseshaht to spend its own money in pursuing these claims. These cuts directly deny, we say, all First Nations, including Tseshaht, with an access to justice. They completely undermine the premise that Canada made, the promise that Canada made in 2007 when it committed itself to a fair, just, and timely resolution of the specific claims through negotiation. And I invite you to go back to 2007 to the documentation and see the promises that were made by Canada, because today they are empty. These cuts we see as a direct response by Canada to the unfavorable rulings it's received in the Specific Claims Tribunal. The cuts are an attempt by Canada to stifle resolution of these ongoing claims. Canada's failure to acknowledge these injustices and provide proper resolution obstruct our ability to move forward. I'm going to invite you to read the entire submission. I'm not going to read it for you. I want to get to the last page. I do have a flight to catch, but I'm sorry. Where we make recommendations. And you will have seen most of these already. The first is more funding to First Nations to proceed. But we also think that the Specific Claims Branch should have a regional office here. The situation in British Columbia, there are regional offices across Canada, but they're not manned, and the only policy they can administer is Ottawa policy. But the situation in British Columbia is unique. We have Order in Council 1036, which exempted from reserves existing roadways. We have the federal policy of saying it wasn't a reserve until 1938. We had the whole Reserve Commission that cut back a lot of reserves, and then we had the establishment of the reserves in the first place that was different, like from the rest of Canada. So we think there's a good case to argue that there should be expertise here in British Columbia on these issues, and that would expedite the research process. There should be collaborative research between Canada and the First Nations. The way it works now is you put in your claim, it's accepted, and then Canada starts flooding you with letters asking for, with utmost respect, stupid things. Like they'll say, oh, we can't read this document, we think, as well as we should be able to. It has to be transcribed. Or they'll say, can you please confirm the footnote that's referenced on the document, when the footnote has nothing to do with the claim whatsoever. And I'm not joking when I say these letters come as a flood. They have the students doing the research in Ottawa, and then they send us these letters asking for little things from the documents, and it just becomes an absolute flood of requests. They should be working together. If there was a regional office in BC, that would be easy to do. Of course, there should be good faith negotiations. Of course, there should not be a requirement that when we settle a claim, we have to relinquish all the other claims. Canada has a policy that if you have a claim before them and they settle one part of it, you have to relinquish their liability on all of them. And that's wrong. That's why so many people are filing a multitude of claims, because they don't want to be caught by Canada's policy of having to relinquish Canada from any liability for all of the aspects of the claim. There should, of course, be the appointment of more justices. The lack of justices at the Specific Claims Tribunal is just hampering things immeasurably. And there, of course, should be continued and improved investment in the Specific Claims Tribunal. So those are the recommendations from Tseshaht. We did set out in the process our thoughts on the current adversarial position and position taken by Canada, and the dramatically negative effect that it's having on the handling of specific claims before it. I want to thank you for allowing me to have made a presentation to you today. Thank you for listening to Tseshaht.
This is just a small window on what's happening with the negotiation phase of the various claims. You've heard a lot about the whole process. A large proportion of the communities and reserves lie within the narrow canyons that are dissected by all of the highways, railways, hydro rights-of-way. There are no large towns here, but a number of small communities eking out a living on the tiny remaining reserves. The transportation corridor has alienated most of the flat or arable lands. Settlers took most of the water, and there's not even enough space to build new houses. They were nearly wiped out in this process. So when Nlaka'pamux nations put in specific claims that focus on improperly carried out alienation of precious flat reserve lands, destruction of access to the fishery, eroded hillsides, etc., the very factors that have so reduced our economy and lives, they don't consider these small value claims. It's not the fact that they're not worth $10 million each that's the grievance here. It's how these claims are dealt with, as of no consequence, not worth negotiating carefully or fairly, not worth anyone's time to come and see the impacts, not worth the time to follow up on questions asked or anxieties expressed, even when assurances are given that they will. We had a prime example last week when Chief and Counsel of the Boothroyd Band met with Canada's claim negotiator about two complex claims involving railway and highways rights-of-way through 7 reserves. It was clear that the junior negotiator was very junior, was not informed of the facts of the claim or even how the offers had been arrived at. This was the second time the chief and 4 councillors had come to Vancouver, stayed overnight because of weather and road conditions, only to have a negotiator read out loud the non-negotiable letter of offer that each of the councillors had in their hand. At the first meeting 2 years ago, the negotiator and Department of Justice lawyer that was called in contradicted each other on the issues at hand. There are issues which Canada dismissed on the basis that it needs further evidence, not about the actual destruction, but they wanted a virtual appraisal of the financial impact to the band of the losses from the destruction of irrigation sources, severance of farmsteads, etc. These are old claims. They were submitted before 2008 when these compensation issues were negotiated on the ground. But this additional research can be readily undertaken. It would save Canada and Boothroyd the cost of splitting claims, rewriting, resubmitting them, or the other large expense of a tribunal hearing. Canada promised to come back to the band with a decision on a very common sense approach. The questions got lost within the Specific Claims branch, and they haven't been able to find a paper trail. The community's 2-year wait for a possible common sense resolution was waved aside. Canada's negotiator justified this because these were small value claims, a low priority claim for Canada, even while the issues and damages presented in the claims had almost wiped out the community. In the process, the offer of $50,000 to cover negotiation costs was apparently arbitrarily reduced to $25,000. 2 years ago, Chief Janet Webster of the Lytton First Nation gave a paper to a Specific Claims conference where she expressed her frustration at the settlement of claims process. This is just the writing of the settlement agreement. Just getting a fair settlement agreement for a very small value claim had taken 3 years, cost Lytton 1/3 of the settlement. The problem was Canada was trying to develop a template agreement that would cover all small claim settlements, so the release clauses were absurdly broad. Lytton First Nation and Boston Bar First Nations were the early guinea pigs of their template. They paid dearly as their legal counsel had to keep sending back draft settlement agreements that did not fairly represent the issues. That was 3 years ago. Canada continues to cost Nlaka'pamux communities more than $50,000 offered to cover negotiation costs. It's the same problem. It's with the release clauses that Canada continues to fill in, include more than was dealt with in the claim. Canada appears to focus on making small value claims into no value claims. Thank you.
We've had some submissions about the following issue. Does limiting research for claims, specific claims, at the very beginning stage research actually limit the number of claims that people become aware of? And some people have told us that it doesn't. That people don't become aware of their specific claims because they've got research money. They've got research money, they can develop them. But you have a large number of specific claims you've identified, and it's not because of funding, it's because you research one claim, you become aware of another, or it's historical memory, or it's academic literature, or whatever. So that, I'm not saying it's necessarily a conscious strategy, but if the theory is we limit research, eventually the industry will die. It isn't going to happen because people will be aware of claims anyway. They're not going to go away. They're just going to take longer to deal with. They could get more expensive. There'll be frustration. But limiting funding is not actually going to, in the long run, limit the number of claims that people will be aware of and want to pursue. Is that right?
It limits them initially. I mean, they're always going to come out in the long run, but it's limiting in that the longer a time ago that the grievance took place, the less evidence we have, and so it limits it in that respect. And it's certainly true that the more files you open, the more claims you file. So if you don't open any files, you'll see less claims, but they're not going to go away. They're still going to be there till somebody does look at that file.
And so with respect to Canada's policy, it's a reverse onus policy whereby the band has to submit a claim regarding Canada's breach. So it's ironic that many of the breaches are ongoing by Canada. Canada provided the permit authorizations and the takings, and the band has obligation to file their claim to seek compensation and to seek Canada to fulfill their statutory and fiduciary duty. And so most bands, to my knowledge, have, I would say, anywhere from 5 to 10 claims. And these involve reserve creation issues, takings through Section 35, surrenders of reserve lands, and other dispositions. And so many reserves in British Columbia are small, have a lot of right-of-ways through the lands, and so quite often the Crown and third parties are, to this day, in trespass. And so the difficulty for the First Nation is that they have the obligation to research, so they have to go to Canada for funding, and Canada advises the First Nation, you have to belong to one of the 6 regional groups in British Columbia. A lot of my clients are independent First Nations. They don't belong to these regional organizations. And so they have to make a choice. Do we get funding? And if so, we have to belong to one of these organizations. With all due respect to these organizations and their researchers and counsel, our clients decide to retain their own researcher and our legal services. And so really it's Canada's policy by dictating where the funding goes is a violation of the community's right of self-determination regarding how they can access funding to pursue their settlement of their specific claim. In respect to Canada's minimum standard is that the First Nation will submit their claim. Quite often the claim will involve hundreds of documents. I wouldn't say on average, but a lot of claims are on 400 documents. And so Canada will review it. And so you actually have to make sure that the researcher has all the documents in order. If not, it's rejected. Then the researcher has to redo the documents and the index. And it's very time-consuming. And so after the Canada says you've met the minimum standard, they'll go through the review process. Previously, Canada would provide a copy of their historic report and also their legal analysis. Today, we don't receive their historic report. The First Nation receives a letter saying the claim is either accepted, partially accepted, or rejected. And so it provides a choice for the community. However, there's not the supporting information why a claim is rejected. It's just outright rejected. And so that's the difficulty for a community is trying to ascertain the basis for acceptance and the basis for partial acceptance or the basis for rejection. So then if it's accepted, you negotiate. In my experience recently is that Canada's negotiators aren't negotiating. They have a mandate and directive from Ottawa. And basically, it's a take it or leave it. They'll say, here's the principle for valuation for the historic loss, And previously, you'd go back and forth and have negotiations and try to arrive at, fair market compensation. And my experience of their new negotiators is that if you're lucky, you'll have 1 or 2 sessions and that's it. Everything else is done by teleconference. And so really, their negotiators don't have sufficient mandate to find or to achieve a fair resolution of the claim. There's always a debate regarding what is fair market compensation. And so there's a lot of debate, and it takes a long time to arrive at that fair market compensation. And it's done by appraisal and through negotiation. And so Canada has a very, very narrow viewpoint on how to arrive at fair market compensation. And they don't fully consider the compound and the loss and investment opportunity of the First Nations. So there's always issues regarding principles for valuation. In respect to claims that are rejected, some claims are actually partially accepted, and then the First Nation has to make a choice. Should we accept on a partial basis, move forward, or appeal to the tribunal? Most First Nations will appeal to the tribunal and then go through the tribunal process. And for the tribunal process is my experience is that it is effective in filing the declaration, but there is no funding for First Nation to file a declaration. So they have to do their own work out of their own pocket. They can only receive loan funding at a certain point. I believe that's after Canada has filed their response. So really, the First Nation is self-financing their involvement in the tribunal up until Canada files their response. So the First Nation may have incurred X amount in legal costs, X amount in community costs without reimbursement from Canada for their costs to pursue a remedy of their claim. And I heard earlier about the concept for mediation. There is no possibility of mediation through this process. It's either a limited negotiation or you go through the adversarial tribunal process. And I would recommend that the guidelines and the rules of procedure allow for compulsory mediation. It would make the process more efficient and more fair. And so Canada is fighting with the claims on every case management conference, every step of the way, and they have the manpower. Most of the claims before the tribunal, Canada will have a team of 3 lawyers. And we have 5 claims in the tribunal, and so Canada has 4 sets of different lawyers on each claim. And so they're manned up and they have the resources to combat the First Nations on their tribunal process. With respect to the tribunal process, it takes a long time to compile the common book of documents. There's lots of documents at stake, and it is a very long process to have an agreement with the Crown on the common book of documents. And after you have the documents agreed to, then you got to move forward with the proposed agreed statement of facts. And again, it's a give and take of the Crown, and if you can get there, and then you see this whole process of preparing for the hearing, there's delays, and for our clients have real concerns because they have elders who want to testify, and the hearing date might be a year away or not even be scheduled yet. And so we're having to face the reality of having dispositions of the elders to have their evidence recorded pending a hearing. And that's a real concern for the communities regarding the potential loss of elders and their evidence that is highly relevant to many of these claims. So with respect to recommendations, is this having more capacity available to the First Nations, whether it's financial or support services, and disclosure of Canada's positions, disclosure of Canada's historic report, and having more strict timelines in place for Canada to respond to the claims, and to also to have the claims pursued through the tribunal process or through mediation. and to have a more of a streamlined process for documents. Quite often on a claim, you might have really a few key documents, the smoking gun. A lot of the other documents are really just ancillary, and so here the Crown needs time they want to have time to do more research, do more documentary investigation, and so some of our claims are pursuing some of the claims are over 1,000 documents. But really, there's only a few key documents that give rise to the issue of the claim and to compensation. And so we need to look at how we manage these documents to provide for efficiency for a resolution of these claims, because ultimately the resolution provides funding back to the community through a settlement, makes I won't say the community whole, but it addresses these outstanding grievances. And so I know that through settlement agreements, the community can really benefit by these settlement agreements by having the monies back to the community for other community purposes. And so I look forward to your report and recommendations, and thank you for hearing me on short notice.
You mentioned at the beginning quite a striking statistic. You said that average or typical band has 5 to 10 specific claims. Are you talking about bands in BC, bands across Canada, bands in the coast? And are those claims that have actually been formally identified and filed, or that's just claims that communities are aware of?
So my indication of average of 5 to 10 are involving my clients that I'm familiar with. Right. And so some of these clients have filed claims or researching their claims or have claims to the tribunal. And so quite often you'll see a community that will have one filed claim, one that's being researched, maybe one before the tribunal, one through negotiation. So you have the full spectrum, and you actually have the full spectrum of from a simple permit to a surrender. And so it's quite common to see all the different types of illegal dispositions on a small parcel of reserve land in BC. So a lot of the communities in BC will have more than one reserve. Quite often will have 10, 20 reserves. And for any one reserve, there's always a breach. It's not if there's a breach, there is a breach.
The reason I'm asking, and I think your response was consistent with, is one theory is we're starting to tail down on the number of claims that Canada's going to have to consider. We've had a lot of presenters say one way or the other that's not the case. There's a lot of claims out there that people are already aware of that are emerging, and if anything, the amount of money available for research and presentation is going to have to constantly go up. It's not as though we're at the tail end of this historical phenomenon.
Right, and so with respect to these outstanding claims, I'd like to be recommending that the First Nations do I call it a quick claim. You have one document filed as a claim, and then that just forces the issue then. And so quite often these claims will say that there was perhaps a below fair market value for the lease. Just file the lease saying Canada breached by allowing this lease by proving it below fair market value. And so we're actually anticipating doing these quick claims to circumvent the lengthy process and to force Canada to the table to address these unlawful dispositions.
So the idea would be to get the stage 1 clock running right away.
Yes.
Because probably not going to be settled at stage 1 anyway and get to the tribunal faster.
That's correct. And then the Crown has to make their disclosure documents to the tribunal process.
Thank you.
But we find and try to find ways to work within the systems to make things work for us. And we have, on some occasions, through our land claims process, through negotiations on a couple of our claims that we've been able to settle. 2 claims in the past 20 years. We were somewhat satisfied with the outcome, but there are still a lot of claims out there for Tsuut'ina. And as well, all of those tribes of Treaty 7. I may not be able to speak on behalf of those tribes right now, but I know they share my comments. The current process of how claims are addressed, especially with the caps that have been put in place, do not allow us justice to what we believe is outstanding, and it has been for a number of years. I will speak more to all of this later, but I do want to tell you, everything that I say here today is the truth. I cannot lie. I carry my eagle feather with me everywhere I go. That was given to me by my grandfather. That told me, you always have to tell the truth. Elijah Harper did it for us, for all of our people, during Meech Lake. And I will always hold that man dear in my heart. He became a personal friend. And we all cried after his loss, because in our world, in our minds, he was a real warrior. I'll turn the mic back over to my legal.
I will carry on with comments directly related to the specific claims process, and some of it specifically related to the Specific Claims Tribunal. I'll start with a lot of this is a reiteration of things that have already been said, but just to bring the points out. Canada has withdrawn all kinds of resources from the specific claims process. Cuts to claims research units, the end that really mean the end of the claims research process and the end of the claims backlog, by way of making sure that no new claims can come into the system from First Nations who can't get the funding to properly prepare them. Cuts to Library and Archives Canada have made getting access to documents challenging. Destruction of documents and redacted information, increased ATIP costs. All of this seems to indicate a lack of intent to negotiate meaningfully at the pre-tribunal stage. Next slide, please. In terms of misuse of the tribunal by Canada, the tribunal appears to be an alternative to negotiation for Canada, putting forth take it or leave it offers, lowball offers, and behaving at negotiation tables in a way that invites First Nations to go to the tribunal. And then once they get there, the Crown uses a vast amount of resources to avoid settlement. The new minimum standard provisions in the Specific Claims Tribunal Act used by Canada to dramatically increase the work involved in preparing the claim. And the legislation says it should be reasonable, but these minimum standard provisions are far from reasonable. And I think another individual who spoke before me said that suggested that Specific Claims Tribunal could be given a rule, a supervisory rule over whether minimum standards have been met or not. That seemed like a good suggestion to me. Excluded claims and partial acceptance of claims. There needs to be a better process for the resolution of treaty land entitlement claims. Smaller claims that hinge on treaty land entitlement claims can't go forward without first dealing with these treaty land entitlement claims. And attempts by Canada to settle the smaller claims make it so that these smaller claims could compromise these larger settlements because of what you have to accept in order to settle those smaller claims would suggest that you've accepted their interpretation of the treaty. Excluded claims and partial acceptance, again, I'll just make a few more comments on this. Canada has reduced the backlog of the claims by eliminating certain categories of claims. By, for example, living up to key treaty promises, claims of an ongoing and variable nature have been eliminated. Traditional mode of life promises in the treaty are an excluded category, and these can be particularly problematic. So in the process before the tribunal, the stall tactics and bad faith negotiating, making it difficult to access documents, I already have mentioned this, but asking First Nations to deal with smaller claims without first having an avenue to resolve the larger ones, increased rates of rejection, and which lead to false or misleading backlog statistics, partial acceptances requiring broad releases, confidentiality agreements to keep details of bad faith tactics from the Specific Claims Tribunal. Prohibition on the introduction of new evidence, not really negotiating anything, the unilateral imposition of terms around the negotiation. So when you receive these letters of partial acceptance, for instance, there's no way to go back and say, have any kind of input into that. It's a take it or leave it, and prevents you from moving forward in many cases. Negotiation capacity funding has been cut, refusing to fund valuation and expert reports. Sharp dealing, really changing negotiators, changing positions, changing mandates. Expert reports agreed to at the table and paid for by First Nations that become useless because the mandate or requirements change afterwards. An unwillingness to stand behind expert reports and valuation reports that were already provided and agreed to earlier. These are all the sort of tactics that really indicate a lack of willingness to negotiate. Do you want to say anything before I mention recommendations?
I want to speak to a couple of those points raised by my legal counsel. The one issue regarding those cuts to our specific claims departments from our fiduciary have impacted everyone across the board, including their own institutions. For years, as researchers across the country, we have always voiced our opinion of the cooperation that we get from places like the National Archives when we're trying to collect our documents. For Tsuut'ina, this is a very critical issue. In the years of 1920 to 1940, our Indian agent, Dr. Murray, found it fit to have people of our own tribe take our documents off the reserve and literally burn them. It has been a real exercise for me to try to acquire these documents from whatever sources were available to me. In fact, when I was on my way to the National Archives on one trip in 1993, I happened to look in the local newspaper, and what did I find? An article that stated, "Trail costly to the end," which talks about the bureaucratic paper chase that consumes time and money, and the ending words of it are that the government have their own shredders and don't break any rules. I was very concerned by the time I got to Ottawa, and I contacted my chief and counsel, who agreed with me that we needed to address this issue immediately. In doing so, I was provided and sent a band council resolution signed by my leadership, addressed to Dr. Jean Walleau. And in his response is basically that the National Archives was not shredding documents. We found evidence of that action actually taking place. I wanted to mention that to you because I know as researchers across the country, we are having problems because of those instances and others, and I believe it's all related to the government's lack of support to provide enough resources and funding for us to continue to do our work properly on behalf of our respective tribes.
I know we're running out of time. You have a copy of the presentation with the recommendations, which are generally consistent with the recommendations you've already heard. The one thing that Mr. BigPlume wanted to emphasize, I just want to make sure, is the cap on the amount of damages and the way that it prevents certain claims coming from, like it doesn't give an avenue for claims that go beyond that cap. There's nowhere to go. There's no good process for resolving those claims, and that means that you can't get access for some of the other claims either because you have to wait. So removing that cap, and then also limitations on the way that claims need to be framed so that First Nations have more freedom to frame them as they see fit and not according to a prescribed measure.
Jim mentioned Elijah Harper, who's also a personal friend of mine, and I've never had a chance before to speak publicly after his passing. He was an extraordinary person, and a couple things people should remember. One is he had this gift of hope. No matter what happened, and a lot of things happened in Elijah's life personally as well as in his community, he was always a hopeful person, and I don't know if everybody knows this, he was an extraordinarily inventive person. He was a person who always had 1,000 ideas about business, government, politics, society, education, and not bad qualities to remember when we're looking at the issues with specific claims, hope and inventiveness. When I testified at Parliament 5 or 6 years ago, what I said was, this is a sound piece of legislation, but its success will depend on whether the political will and the diversion of resources will continue. We have heard over these 2 days of hearings actually an entirely consistent feedback in this respect. The kind of message we just heard is consistent with what input has been from everybody. The stage 1 was supposed to work way better because there was a stage 2. If there's access to a tribunal, then there'll be an incentive for stage 1, the negotiations, to work better, and we're hearing consistently from everybody, without exception, stage 1 is not working well. With one, I think, possible dissent, we also heard stage 2 is actually, to the extent that there are the resources there, that there's judges available, a lot of good things have happened at stage 2, that finally there's an independent mechanism that's transcended the conflict of interest, that some of the rules that Canada and the AFN and the claimant community worked out have actually worked very successfully, that it's culturally sensitive, that hearings take place in the community, nobody's had any complaints about the caliber of the people who've been appointed to the tribunal. So there's been some enduring, so far, success, some obviously very significant disappointment. In terms of where we go from here, we've heard a lot of excellent recommendations, which can be mixed and matched and combined in various ways, and I think there's all kinds of ways we'll be thinking about them to incorporate the many constructive suggestions and put them in some sort of package of recommendations. Just a couple things by way of humility is, one is, and this is no disrespect to my esteemed colleagues either, 3 experts just saying here's some ideas cannot possibly be the sure path to the best way to fix this system. The best way to fix anything is to get everybody involved, and that's been proven by experience, right? What actually worked with this system was the product of the AFN Canada dialogue, which was a remarkable success, that actually agreed on the legislation and then agreed on the rules of the tribunal, at least agreed on a submission on the rules, and the rules have actually worked very well. So whatever we recommend, I'm hoping, this is just my view so far, will feed into a renewed intensive engagement between the Assembly of First Nations and Canada. Not here's some suggestions and Canada picks and chooses, takes some and takes others, but a real renewed engagement so that there's that dialogue again and problem solving again, and the system gets more fully on track again. And I think that's especially important because this is a system. Like we could say, for example, maybe get rid of stage 1, do everything at stage 2, but if stage 2 is under-resourced, if there's not enough judges, not enough money, you don't want to get rid of stage 1. You only want to get rid of stage 1 if all the other pieces are in place, which is the best elements of stage 1 have been accommodated in stage 2 and so on and so forth. So what I'm anticipating is hopefully we come up with some suggestions, but that is not the word to be picked and chosen and disposed of by Canada, but hopefully suggestions that will be fed into a renewed partnership between AFN and Canada. Just another point by way of humility, we did hear from a number of people that this process can't work for all situations. It can't work for mega claims. There may be very distinctive kind of situations on the West Coast and Ontario where there's a whole set of claims with very sharing characteristics, and maybe you need another process for that. And I just want to say, from my point of view, that's fine. Right? This system can be in place for many claims, and that shouldn't stop people from being inventive and constructive about trying to find processes to work for claims of another kind. I'd like to thank the AFN for giving me a chance to be involved in this process again, and Delia and Bob. They're not finished yet, but it's been an unmitigated pleasure working with both of you. So thanks to everyone.
Quick comment, I know it's late. A lot of people in the room have been dealing with these claims for a long time, in my case, over 2 decades. And we heard a statement earlier today that these claims need to be dealt with and resolved in the communities, that it can't be a paper hearing. Somebody's raised that question. In the early days of my involvement in these issues, I was involved in the Indian Claims Commission inquiries, and we went to the communities, and we heard the stories, and we recorded them. And I must tell you, on a personal note, I found those stories extremely moving. So much so that I went home and got my mother and her 5 sisters in a room and recorded their story. My mother was deported to a Siberian labor camp at the age of 4 and went around the world and got her story. So I am a big supporter of dealing with these claims in the communities. We heard from the National Chief this morning that we're here to try and figure out how to make it better, and that's what we're going to do. We've heard a lot of problems, we've heard some suggestions, and we will do what we can, we'll do our work to try and make it better. Thank you.